you'll be happy to know that we'll finish today because we are going to sit until we finish.
That's fine with us, Chair. No complaints.
Just a matter of, I throw this for just a matter of observation. Because Advocate Butler, you made a statement to say that you counted no less than 13 no's, referring to the highs. I think it should be mentioned in all fairness that during the interpretation, some of the highs that we're referring to were interpreted as exclamations, not as no's.
Yes, no, Chair, I'm happy to put up a list of those no's if it would assist. It does not take into account anything that was disputed to be a no. But if it would assist, I'm happy to do that.
Yeah, you may proceed.
Thank you. Chair, the evidence shows a gradual and persistent escalation of the respondents' demands and conduct. So we went from the 8th June, which was the first WhatsApp exchange between the parties, where you saw the respondent asking simple questions about Ms. Mengo's child, about her appearance, how she keeps fit. And within the first hour of that WhatsApp exchange, he asked her for a photograph of herself and then proceeded to continue to ask. She explained that she didn't have any. He kept persisting. He then saw what she says was a status picture of herself fully clothed that anyone could see. He says that's a photo that was sent to him, but whatever it is, what they agree on is that he said, asked her to send one with the top half removed. Under cross-examination, the judge president explained this by saying that the reason he'd asked that, Kulula Mutla, was because in the photo she was covered up and that he could not see her shape. And you recall, he even made a hand gesture during cross-examination to depict the shape of a woman's body. You'll find that on day 8, 9 July 2025, pages 27 to 29 in the transcript. So and then from there on, the conversations escalate, the sexual content, which my learned friend calls salacious. I don't like that word, but the content of the conversations were sexual. When one looks at that, they escalated. They became more persistent, more frequent, and more sexual. And when one sees how these things escalated, from asking for a photo to asking about sexual positions, for example, asking to be intimate, saying it was possible that they would melt if they were together. We would submit that when one looks at that in context, it is not improbable that on the 14th of November, that the respondent called Ms. Mengo to his office, that he then escalated things even further and attempted to unzip his pants and pointed to his penis. That you will see that evidence in day 6 of the transcript, 20 January 2025, page 66 to 67. Now, on the question of the 14th of November, the chairperson asked a question around Ms. Mengo's credibility around the 14th of November, and if I understood correctly, the chair suggested that her inability to decide whether it was the 14th or the 15th of November amounted to a question around her credibility. If I've misunderstood the question, Chair, you will correct me, please. Let me say this, factually, at all critical points, Ms. Mengo has been clear that she was not sure if it was the 14th or 15th. She said that from the first time she reported this officially to Krokwana. And even then, she said it was the 14th or the 15th. And he confirmed this in his evidence under cross-examination. You'll find that on day 5, 9 May 2025, page 47. When she was, we then had a tribunal meeting, like a case management meeting, I forget what they were called, a tribunal inquiry meeting, I think it was called, when Ms. Mengo's legal team were asked expressly to obtain a date from her. And if I recall correctly, it was for purposes of obtaining video footage. But she was asked to pin her colors to the mast and give a date, 14 or 15. And her legal team took instructions. There's submissions before the tribunal. And her instructions were that, to the best of her knowledge, it was the 14th. That's the first time she said it's definitely the 14th. And that has been her position in evidence since then. She was specifically asked on the 23rd of January under cross-examination about this, and she confirmed that as far as she knew, the correct date, as far as she could recollect, was 14 November and not 15 November.
Who came up with 15?
I think in the affidavit, in her complaint, she said there was language used around the next day. I think the language was the next day, which then suggested the 15th, and that raised the question. And she did testify that she wasn't sure and that she tried to put together things that had occurred in that time period to pin down a date. But what's important is that that she has, it's not that she was inconsistent in her version. She has been clear that she wasn't sure it was the 14th and 15th. And when her legal team were forced to put something on paper, we asked her and she said, to the best of her knowledge, 14th. Now, the respondent is at pains to deny that the incident of 14 November took place. And it is interesting that that there is a vehement objection to the fact that the 14 November incident took place and to certain WhatsApps, sexually explicit WhatsApps. There's a denial that those took place. Those two things seem to be of particular concern. Now,
I think there are problems around that issue. Isn't there a time when she was asked to indicate whether it was in the morning or in the afternoon, and she was not able to clarify whether it was in the morning or in the afternoon?
Chair, I can't quite recall. I'm happy to check and come. I don't want to make a submission that's not correct. I can't quite recall whether there was an issue of morning or afternoon.
I think it was sent out that she should tell whether it was in the morning or the afternoon. I think the chair requested that she tells us whether it was in the morning or in the afternoon.
I'll have a look at the transcript and see what was said. But we would submit that the respondent that the video footage that we saw and the concession by Ms. Nkai show that there was an opportunity and an occasion for the incident to have taken place on the 14th of November. Ms. Nkai said she could not say, she was not watching the Judge President's office at all the time, and she did leave her desk. She conceded that. So it's possible, and there were other concessions, but it was possible that it could have happened. And we would submit that given this gradual escalation of sexual demands from the complainant, that it is more probable than not that the incident on the 14th November did in fact take place as she describes it. But even if this tribunal is unable to find that the incident of the 14th of November took place as she alleges, we submit that that does not negate a finding of sexual harassment here. That the remainder of the respondent's conduct evidenced on the WhatsApps alone, even if one is not even to look at all the WhatsApps, but simply to look at what he admits, we submit that that constitutes sexual harassment and gross misconduct. And the same applies to the other issues that he denies, the photographs, K89, that he denies having sent. If this tribunal is not comfortable making a finding that he did in fact send them. And we submit that you can make a finding. Mr. Moller confirmed that he could not rule out that the respondent had in fact sent them from his phone. But if you find that you can't make that finding, even so, we submit there's blatant sexual harassment here. The truth is, if one would just, well, I'll come back to this in due course. Let me keep moving for now. Now, if I can move on to the last substantive section that I'd like to deal with, which is just to try briefly to provide a response to some of the respondents' arguments that come up from the heads of argument. There is a refrain throughout the heads of argument, and there is a substantial section of the heads dedicated to this, that the complaint has only been made to embarrass and humiliate the respondent publicly. It's contended that the way in which this complaint has been handled by the complainant's team, legal team, and the evidence leader asks this tribunal to adopt legal principles specially tailor-made for the identity and personality of the accused. And I quote from the respondent's heads, to venture into some public humiliation exercise in the hope of evoking public outrage against the respondent. That is at the respondent's heads, page 5, para 7 to 8. So we would submit that's a suggestion without any merit. It's quite frankly not borne out by weeks of evidence and the documentary evidence that is before this panel. That's particularly in circumstance where the manner in which the respondent has allowed his defense to be run on his behalf involved a particularly brutal and humiliating cross-examination of the complainant over the course of 4 days. He permitted her to be, because he gives instructions to his counsel, he permitted her to be called a liar, to be accused of acting on behalf of some unknown third party, to be accused of undermining the broader cause of sexual harassment for other women, for all women, amongst many other things. So if anyone has been humiliated and demeaned in these proceedings, it's the complainant. What we saw unfold during cross-examination was enough, quite frankly, to put back the very noble attempts of our legislature and our judiciary to protect women from the scourge of sexual harassment. And the fact that the judge president thinks that the way in which the complainant has run its case is designed to humiliate him really bears no resemblance to any facts that this tribunal has had placed before them. If the suggestion is that the fact that the judge president had to sit through a reading through of his personal WhatsApps that he admitted to having sent, and to suggest that this was demeaning and humiliating, then it suggests that he knows that his own conduct was inappropriate and contrary to what is expected of a judge. Now, another argument that was raised for the first time in cross-examination of Ms. Vetten was that the judge president, it was put to her that the judge president would contend that what we see playing out in the WhatsApps was in fact a Xhosa cultural practice. And that actually what was happening was that the judge president was courting Ms. Mengo, and that this practice requires, on his evidence, persistence, and in effect not accepting no for an answer, because the way in which the practice evolves is that the woman has to be coy and pretend to refuse a man's advances until eventually she gives in and accepts a relationship with him. Now, the judge president claimed that the use by Ms. Mengo of the monkey with the closing eyes emoji gave him an indication that that is what was happening, that when she used the monkey with the closed eyes emoji, she was indicating shyness. And that meant that they were engaged in this practice. Now, that defense was never raised with Ms. Mengo. It wasn't put to her. It wasn't put to any other witnesses. It wasn't raised in the Judicial Conduct Committee. It was raised for the first time in these proceedings, was not raised in the respondent's affidavit. So this tribunal doesn't have the benefit of Ms. Mengo's response to that particular argument. But she was asked in evidence about what she meant when she used the monkey emoji and with the closed eyes. And it is notable that she did not mention being coy or shy. She said She was embarrassed. It was there to connote embarrassment. So her version is different to his on this. But in any event, the Constitution is clear. Everyone has the right to participate in their cultural practices, and the language of the Constitution is the cultural life of their choice and to practice their culture. But no one exercising these rights may do so in a manner that's inconsistent with the Bill of Rights. So in other words, a practice of culture must be consistent with the Bill of Rights. And ignoring a woman's refusal to be intimate with you or to send photographs of herself, clothed or otherwise, is self-evidently, we would submit, in conflict with her right to dignity and her right to equality, amongst others. So on the issue of the cultural practice, one, we submit this tribunal ought not to take that into account because it wasn't properly placed before you. It wasn't put to Ms Mengo or to any other witnesses. And it's an opportunistic argument that was raised only under cross-examination of Ms Vetten. Two, even if it is an argument that this tribunal wants to consider, we would submit that this tribunal must have reference to the Constitution and must take note of the fact that such a practice would, we would submit, not survive constitutional challenge for the reasons I've articulated. Now, to move on to the next issue. And again, these are issues that have come up through the respondents' heads of arguments. The respondents contend that the respondent could not have known that his conduct was not welcome. And they say in their heads of argument, and I quote, "Quite how the respondent in this case ought to have known that his overtures would be unacceptable is unclear." That's at paragraph 65. Well, I've made submissions this morning about various objective facts that he ought to have taken into account and that this tribunal ought to take into account in determining whether or not the conduct in at issue was welcome. But what's interesting in how the judge president chose to deal with the situation in which he found himself as a judge is that he did not once stop and question his behavior. He did not question whether it was appropriate. He ought to have, had questioned whether this conduct, this sexual relationship with her, with a secretary, had the real potential to be unwelcome. The first time that he asked her if he wanted to just be friends came weeks after he'd been engaging in this kind of relationship. On day one, he asked her for he sexualized the conversation. On day one, he ignored the fact that she was very clearly refusing to provide him with what he wanted and making up excuses. I'm at the gym. I don't have any pictures of myself. I'll take some later. All of that happened on day one. On day one, he asked her for a photo with the top half removed. So it is, we would suggest, misleading. We would submit that it's misleading to say that the judge president could not have known that his conduct was unwelcome. It is possible that there were instances in the conversations where he wasn't sure. Absolutely, we don't deny that. But what is absolutely clear is that sexual harassment happened on day one of this engagement, and it happened in various conversations thereafter. We do not suggest that it happened in every single conversation, but that is why Ms. Vetten's evidence is important. Sexual harassment, you can consent, she said, to one thing, but not to another. Sexual harassment must not be looked at here in relation to the whole WhatsApp conversation as if something that took months, that you're asked to look over months of communications to determine whether that was sexual harassment. Sexual harassment happened here on various instances in those months, and quite frankly, it happened on day one. That's the very clear, obvious finding we would submit. And we would submit that a reasonable person in the position of the respondent would, at the slightest suggestion that she was not responding to him or ignoring him, not have persisted by sending listening ear emojis or prompting her with comments like "twaka," silence, but that a reasonable person would have stopped engaging with her on issues of sexual content early on. And a judge in that position ought not to have engaged with her on these topics. So when the respondent asks how he was meant to know that his conduct was unwelcome, that is how he was meant to know. A judge has to, in all conduct, personal or professional, maintain the highest standards of integrity. To engage in a conversation like this where he asks for sexual pictures on day one that he first starts talking to someone is highly inappropriate. He ought to have stopped communicating with her as soon as she refused to give him photographs. On the question of, which was asked to the evidence leader by the chairperson about Ms. Moreletwe, the question seemed to suggest that that the fact, let me start here. There was a dispute between Ms. Moreletwe and the complainant about when Ms. Moreletwe left the complainant's hotel room. Ms. Moreletwe said it was 9 o'clock, the complainant said it was midnight. And there was a suggestion that that impacts on the complainant's credibility, because she made up this midnight time as a way to challenge Ms. Moreletwe in some way. Now, we would submit Ms. Mengo didn't tailor a version or produce a version to attack Ms. Moreletwe. She was consistent that it was midnight. She was cross-examined about it. She was consistent it was midnight. In fact, she even says she gave Ms. Moreletwe a thank you card to thank her for staying late because it was so unusual for her to do so. She says the next time not the next day, but the next time when she came back to Pretoria, she gave her a thank you card specifically for staying so late. And that you will find in the transcript of 8 May 2025 at page 7. And it does not assist Ms. Mengo to lie about this. It does not assist her to say that she left at midnight instead of at 9 o'clock. But what is clear is that even when challenged, Ms. Mengo was consistent. She said she stayed late, it was midnight. It was so late, I thanked her specifically. Then the narrative that the complainant...
I must tell you, I think we don't understand it the same way,
okay.
the same context, because the bottom line of complainant's evidence is that when she was in Makanda to compile what she says was the second complaint, she didn't have any copy of the initial document. Lo and behold, these documents are identical. Even the grammatical errors are identical. With all due respect, it makes nonsense of the argument that she didn't have a copy of that one. It must have been embedded either in the memory stick or in her laptop. But my problem is this. She extends Moretwe's stay at the hotel in order to pave the way for the argument that she was not left, she did not have any copy of the document embedded in her laptop or in the memory stick. To perfect that argument, she extends Ms. Moretwe's stay at the hotel to 12 o'clock.
Chair, that is an argument that we would refute, that we would say it doesn't have merit. She said it was midnight because she is insistent that that's when it was. This tribunal will make a finding on that. But what is absolutely clear is that even this thing of the two complaints is a bit of a red herring. You can talk about her credibility, but go back to the WhatsApps. When you have to look at misconduct, when you have to look at what this tribunal has to consider, look at the WhatsApps. Look at the fact that Ms. Mengo hid nothing from this tribunal. She did not, in fact, that's the next thing I want to talk about, which is But there is a suggestion that she tailored evidence, that she came up with versions. But if that was the person that was before you, she would not have given you every single WhatsApp on her cell phone after 2 years of having that phone. She provided that. She may have attached some of them to her complaint. But we've seen how many pages those WhatsApps run to. She took screenshots of some of them and attached them to complaint. But when the complaint proceeded and she was asked to give her cell phone to the evidence leader, she handed it over. And what we have before us is a full set of WhatsApps that many of which make her look bad, quite frankly. If she was the person that was sitting here trying to construct a version, she would, I submit, have deleted things that made her look bad. She did not delete them. And when she's asked about the things that are difficult for her to answer, she says, I don't know, or I was frustrated, or I said this because I was being sarcastic. She tries to engage with it. This is not someone who's trying to hide evidence from this tribunal. In contrast, the respondent has deleted every single message from his cell phone. He admits to having done that. He didn't want his family to see it. That's what was his evidence, as I recall it. So you're faced with a situation in which this complainant has, we submit, come here. She may not be entirely consistent on every single fact that's put to her. But no complainant in a matter like this is consistent, can remember every single date perfectly. And if there are things that are inconsistent in her version that you find to be problematic, they do not negate the fact that you have WhatsApps before you that show sexual harassment. And once you have sexual harassment, you must get to misconduct. Now, Chair, we will submit that this case requires this tribunal to assess the conduct of the judge president and to determine, as we've said, whether his conduct amounts to gross misconduct. The evidence is lengthy and voluminous, and it requires this tribunal to venture into realms of WhatsApps and emojis and sexual innuendo. It's messy, it's uncomfortable, it offends our sensibilities, but it must be done. And as the tribunal does this exercise, embarks on this exercise, I would ask the tribunal to bear in mind that the expert evidence before you and the evidence of the code on good practice under the Employment Equity Act says sexual harassment is not just one incident, it's persistent, but it doesn't have to be. And what we see in these WhatsApps, as I've said, is that day one of the WhatsApps constituted sexual harassment. This panel must therefore ask itself, on a conspectus of all the evidence, whether the conduct of Judge Mbenenge, not the conduct of Ms Mengo, the conduct of Judge Mbenenge is conduct which is acceptable of a senior judge and leader of the judiciary, and whether it's conduct that if it was repeated by other judges in the future would meet the standard that we require of our judges. If not, then you must find him guilty of a breach of these standards and of gross misconduct, for the simple reason that he ought, at a minimum, to have known that what he was doing was wrong and in conflict with the requirements of his office. And so we would therefore ask this tribunal to find Judge President Mbenenge guilty of gross misconduct. Chairperson, I haven't dealt with various things that are in our heads only because you've given us an indication not to do so. You've read the heads carefully. But if there are other issues, I'm happy to deal with it now or in reply. Thank you.
One of your early statements, Advocate Bartlander, was, this matter is not complex. I don't know, I'm not sure whether I should agree with you.
Chair, I said the question for you was not complex. The matter is complex, certainly.
At the end of the day, isn't this the question? Well, let me say, actually, should we find that the persisted with his communication with the complainant, even though it was clear that his messages or his approach was unwanted. Unless Mr. Sikakani argues otherwise, the likelihood is that we'll find that there was sexual harassment. If somebody persists in a conversation like that, where it is clear that communication is unwanted, the likelihood is that we'll find sexual harassment, which therefore means that the real question in this case is where this message is unwanted. Is it clear that these messages were unwanted? I think that's the main question. And then we'll have, in answering that question, there are a lot of factors that we'll consider and so forth and so on. And perhaps, as they say, the devil lies in the details. And there are so many aspects to this case, which we will consider. But what I would like to raise is, I think maybe I asked for this about the messages that if we find that have been initiated by herself, we have discussed that. Were there any flirtatious messages from her? If we find that there were flirtatious messages from her, then what do we do with that? But your argument is there were no flirtatious messages from her.
Yes.
Is that what you say?
Yes, we can't deny that there were messages in which she responded to the sexual questions, like when asked, I don't want to put the wrong words to the panel, but you recall the incident where she said, she was asked once about sexual positions, and she said she likes the word surprise, something to that effect, I'm paraphrasing. We don't deny, and we put to her, we said to her, why did you engage in this way? And she had an answer for it. And her answer was, she just had enough. She'd said no so many times and he wouldn't accept it that she thought maybe if she engaged with him, he'll leave her alone. So she had an answer to that. But what's important...
No, but hang on. If the respondent suggests
that shows that it was wanted,
and then she responds, she's not keeping quiet.
But
she says she's not saying no. She actually says, I prefer a sexual position which comes as a surprise. That is actually an elaboration on what was initiated by the... She didn't initiate that, of course, but then it's an elaboration.
No, it's a response. She said, I like the word surprise. We'll pick up the exact language for you. But the point is, Chair, that's why I said, you must not look at a line out of context. You must look at these WhatsApps in context. So you must look at a conversation. And Lee Vetten said that in her evidence. She looked at conversations. Look at a conversation in determining, whether or not, whatever the question is you're asking, whether there was misconduct, whether there was sexual harassment, whether there was consent. But the point is, the context is important. And when you look, you have to read. I keep saying you have to look at all the WhatsApps so that you see what I call the escalation of this relationship. It's not that this one question about sexual position comes out of nowhere. It comes at the end of months of engagement around this and pushing the boundaries to ask more and more sexually explicit questions. until she gives in and answers. So that's why I say the context of the conversation is important. One cannot say, and it was not open to the judge president to say that in relation to one question, she answered in a way that suggested that that was wanted. That question may be fine. But in relation to all of the many other instances in which he suggested sexual things to her where she refused to respond or evaded, tried to avoid the question or ignored him, those were not wanted. And the truth is that if an ordinary person has to have this engagement with someone else, that's the question. What would a reasonable person think when you look at all of this evidence? We would submit that what is clear is she wasn't a willing participant in this. She was a woman in a position that she didn't know what else she could do. She tried saying no. She quoted the Bible. She refused to send things. And then she gave up. That doesn't mean sexual harassment didn't happen. It doesn't at all. Sexual harassment happened because if that were true, then we could never find sexual harassment because sexual harassment has as one of its elements this persistence. And the persistence is designed to break down your boundaries. So if it is okay to say that eventually after all of this persistence, when someone engages with you on sexual talk about your favorite sexual position, then that means that she wasn't sexually harassed from the beginning. That would be a wrong finding in my submission. It's also not, these issues are not being dealt with by this tribunal for the first, well, it's been dealt with by this tribunal for the first time, but these are issues that our courts have grappled with. Our labor court jurisprudence is replete with cases of sexual harassment and how to weigh up all of these things. And what that shows is that there are complexities around this, and it's not a simple question of, did you say no? I asked you for a photo, you sent a photo, and if you sent it, that was enough. It's not about that. In fact, she never sent a photo. But it's really about listening and reading Ms. Vetten's evidence to understand what people study about gender relations in this country and how men and women engage. That's why I say the way in which Ms. Mengo responded and how she chose to respond, it's not a simple thing. This is a complex thing. The fact that we're having these debates shows how complicated it is.
And you see, you spoke at length about the issue of power. Advocate Skeppers also referred to that. But you know what Mr. Skakane's argument was, an engagement with Dr. Vettel. And I got the impression that Dr. Vettel's evidence was that from A to Z, I don't know whether my impression is correct. It was as if from beginning to end, in terms of power relations, at all times, at every turn, the JP was dominant from A to Z. Now, I don't want to get us entangled in that, except to say that the matter here too is not that simple. You know, a woman has been given by God, or those who don't believe in God, let's say by nature, with the power, absolute power, to decide who has access into her heart. That key lies in her hand. There's not even a duplicate key somewhere, like duplicate key to a Mercedes. That key to her heart is under her absolute control. Now, that's the beginning of power, indication of power. And I become curious, if not uncomfortable, when a witness comes to say, from beginning to end, there was no display of that power by the complainant or by a woman. In this particular case, when Ms. Mengo says, I want money, isn't that an excess of power in terms of interaction? Is it not an assertion of power? The question should be asked. If you say you want pictures or what, I want money, isn't that an assertion of power? And when she says, when the respondent asks for something, she says, and it, isn't that an assertion of power in that context? And when the complainant sends a message to the respondent, and she says, I would like the two of us to meet, isn't that an assertion of power? I want us to meet at the time of my convenience, that is when she's available. I want us to meet in East London, at my place. In that context, is that not an assertion of power? And the respondent, if she wants to meet with the complainant, it is at the complainant's time of convenience, which she is saying in the message. She's saying, she decides which city they must meet. She says in East London. And I don't think the mighty judge president can, on that occasion, when he has got to go and meet, can go to Port Elizabeth when the message says East London. She chose East London. If he wants to meet with her, he must go to the city chosen by the complainant. And he was keen to do that. And then she says, in East London, at my place. Isn't that an assertion of power in that context? If you want your respondent, he wants to meet. If you are in the position of the respondent and emotionally you are overwhelmed or mesmerized by her, what power do you have except to agree to come to go to East London and to her room? And you have got to go to East London. She chooses the city. And she says, when in East London, you come to my place. In other words, when the respondent has got to go to East London, he can't go to the city hall. He cannot go to the city hall. If he wants to engage, must he not meet complainant's terms? At the time of my convenience, to the city that I choose, at my place. And isn't that, in that context, an assertion of power? And then, the matter doesn't end there. I just want to show you how complex this issue is. The matter doesn't end there. The respondent says, when we are there at your place, what if we melt and something, can we become intimate? She says, no. To me, it's an assertion of power. We can't. Why would it not be argued that these instances I've mentioned, and the one we mentioned before, where you say about sexual positions, she says, no, I don't go for that. I prefer a sexual position which comes as a surprise. It is her body. She's got the right to say that. It's her heart. Why should it not be seen also as, at least in that context, some assertion of power, the power that she has about herself? In that context, isn't that an assertion of power?
Chair,
I'm trying to say to you that we must be careful with how we engage these complex concepts of power relations. I mean, if she says, come to me and come to my place, I have to get battled in that. ordinary life will tell us that Zelensky, if he wants to talk to Trump, or Trump wants to speak to Zelensky, Trump can't go to Zelensky. Zelensky must go to Trump. Ramaphosa must go to Trump. Why? It is purely a question of power. You go. Zelensky is in a weaker position and power-wise and so forth. They must go to the big Trump. Now you have a situation where a lady says, if you want to see, I want you, for us, the two of us to meet face to face. You come on such and such a date which is convenient to me. You come to East London and you come to my place. Isn't that an indication of some power? I mean, for somebody to come here and say, from A to Z, there hasn't been any case of assertion of power by a woman, and a woman is always powerless. It's quite surprising. And look, I said to you that the woman has got power. We must recognize that when it comes to matters of heart. You know, when a beautiful, charming, elegant woman is there and a man wants her heart, and the man comes to her and then she says to him, you want me? Catch the stars for me. A man will jump and try to catch those stars. That is an assertion of power. And when a man wants to marry a woman, and whatever, or when that moment comes, where does power lie? A man goes down on his knees, kneels in front of a woman and says, will you please marry me? That you kneeling in front of somebody, you humble yourself to the power that person has. So this notion that a woman may not have power, is it really well founded and real? In relation to matters of heart, in relation to control of that key to her heart, over which she exercises that power. That's why you will kneel in front of her. In that given situation, who is powerful? You humble yourself. So situations arise where a woman can assert power. And for anybody to say that a woman cannot assert power in any situation is an astounding evidence.
Chair, we do not suggest that there are no circumstances in which a woman has power. What we're talking about here is a workplace. We're talking about an engagement between the most senior person in a workplace and one of the most juniors. That's when we talk about the balance of power, it's in that context with what Ms. Vetten said. But in her summary, her witness summary, she talks about what I think you're alluding to, which is that Ms. Mengo, she says, attempted to exercise some agency within the limitations permitted by the complexities of this arrangement. On occasion, she resisted Ms. Benenge's repeated transgressions of her boundaries in ways that were sometimes explicit and direct, as in refusing to provide photographs or engage in sex, and at other times in ways that were implicit, indirect, and ambiguous. There is no one strategy for dealing with sexual harassment that works under all circumstances for a woman. Now, and then she says finally that her changing responses are in keeping with the many ways in which women seek to accommodate, negotiate, and resist sexual impositions. Now, first of all, that's the context in which we're talking about power. But Chair, I want to suggest, and I've already said that I don't suggest that women never have power. That's not the suggestion at all. The balance of power is that it's a balance. It's a shifting balance. I accept that. That was what Mr. Sikakane put to Ms. Mengo, that the balance of power may shift. Sure. But to suggest that women always have power and that women, as the chair puts, have power over their heart, which here we're not talking about power of your heart, we're talking about power over your body. We're talking about an invasion of your most inherent private spaces. Sexual harassment is not about romance, it's about power and sex. And If it was that simple that women held that power to who they allow to invade that space, who they allow into their body, then we wouldn't be a country with the highest rate of GBV in the world. We wouldn't be that because women would have that power. But that's why I say we're not talking about that. We're talking about a workplace context here. So it is in different situations, in romantic, consensual situations, yes, it may be within a woman's power to say, I accept you as my partner, I don't accept you as my partner, I want to have sex with you, I don't want to have sex with you. Yes, in perfect, consensual relationships. That's not what we're talking about here. This is an engagement between, as I say, the most senior and one of the most junior people in a workplace. And in that context, even where Ms Mengo exercises her voice where she can. So I want to just, I think the chair's incorrect about her saying, you must come to East London, you must come to my house. Her evidence, and I've asked my attorney to try and find the transcript reference to you, the evidence was that she wanted to sit down and tell him face to face once and for all this was not okay. And the suggestion was they meet at court, not at her house, because that would be a safe space. There was another instance where he wanted to come to her house and he asked if there were people there and she said yes. He asked, I'm just looking at what the evidence leaders provided me, if you'd bear with me. Yes, if one looks at the transcript, page 1207, sorry, I think it's 1207 of the WhatsApp conversations, the respondent says, upon your arrival in East London, where will you be? And she says, my house. And he says, or we will have the conversation at the office. And she says, better. So it wasn't that it was going to happen at her house. But I haven't, this is what the evidence
can I just try to define you what, sorry, I appreciate your point about it. What I'm saying is, when a person comes to say, I mentioned the word A to Z, I don't deny that there could be that, but when a witness comes to say, looking at this case, there is no stage at which she exercised, the woman exercised power. It becomes problematic.
That's not what she said, though. That's why I read this part of her evidence.
That is the impression I got. If I'm wrong with Dr. Vettel's evidence, that if I misunderstand the evidence, to say throughout, there was no time, there was no occasion at which there's some indication of assertion of power by the complainant. I thought that was the evidence. If I'm wrong, then what I put to you must be incorrect.
Well, I've read, Chair, from her summary. I don't have her transcript before me, but my understanding of her evidence is that there were instances in which Ms. Mengo tried to assert some agency, is her language, within the limits of what she was able to do. And that agency was, for example, resisting or being blunt or where she's sarcastic. But the real point on the balance of power is this. It comes down to this. If Ms. Mengo had done something to upset the judge president, she was doing something in the context of her workplace to make the most senior person in her workplace angry with her or upset with her. I'm simplifying. But that's the balance of power. The balance of power is that in the context of her job, where someone in the context of your job makes sexual advances to you and you rebuff them, you are not sure what the consequences are going to be. And that's why sexual harassment in the workplace is such a difficult thing, that often it goes unreported because you're not sure what the consequence is going to be if you report it. So that's the balance of power. It is the same, for example, in a context that we understand as lawyers, that if a junior advocate was to rebuff a senior counsel that she was working with on a case, that she's not guaranteed that she will get work from him again, or she's not guaranteed that he won't tell other people that she's bad. So the balance of power is in the context in which it happens. It's in the workplace, and that has a particular importance to it. So when we make arguments about the balance of power, it's balance of power in the workplace. It's not balance of power in a consensual relationship where someone proposes to you and you have the power to say, I'm not interested. It's not that. But even in that, there are instances, Ms. Vetten recognizes, that that Ms. Mengo tried to assert herself and tried to use what power she had. On the question of the money, it's not that she just asked for money. She said, if I were to ask you for money, would you give it? And her explanation when she was cross-examined on that was, I know that if you ask a guy for money, they run away. And so it was her attempt to say, let's end this thing. I'll ask you for money. And he then says, money is not everything, and she agrees. So, and that's it. And notably, she never once after that asked him for anything. She didn't ask him for a handbag. She didn't ask him for money. She didn't ask him for a holiday. She didn't ask him for anything else in the course of all of these months. And one would imagine that if what she wanted was in fact this kind of reciprocal relationship, that she might well have done so. But it's notable that she didn't. So
there was something I wanted to ask.
No, go ahead, Chair.
For you to speak to it now before
Yes.
Mr. Skakane speaks out. I think you have alluded to it. And that is that the question of the omission of a series of messages, which Mr. Skakane, I presume, I would like you to deal with it to save time, even before it
Sure.
comes. Some of which would show that she was not amenable to the approach. And the argument, if I understand it, is that a series of them were not alluded to in a complaint, and they were left out. And I don't know whether the argument is that they were exhumed by Mr. Muller. A series of messages which she allegedly left out and didn't even refer to them in a complaint, and that these messages were indicated that she was amenable to that. I could have left it to Mr. Skakane to develop his argument further, but the interest of program or progress, and just to give you a full platform to speak to that.
Yes. No, thank you, Chair. I've alluded to it in my attempt to rush through my submissions, but
You alluded to it. You referred to the fact that some messages were deleted, blah blah, and so forth. You referred to that, but
let
I
me
want
clarify.
to put it more pertinently.
The allegation is that when she filed her complaint, that she did not put every WhatsApp in that you now have before you in this tribunal, and so there's a sense that she was hiding things from the complaint. The first point is, when she did that complaint, she was doing it on her own. She wasn't legally represented. When she did the complaint, she wasn't advised as to what she should or shouldn't do. But in any event, the Act does not require her to put all her evidence up before attached to her complaint. I was just trying to find the exact language of the Act, but I'll find it and deal with it in reply. But the Act requires that when you make a complaint, that you must state the basis of your complaint and the, I don't want to summarize, but it does not require evidence. That's very clear. She didn't have to put every single piece of evidence. What she said she did is she took, when she was with Ms. Moreletwe, she took screenshots of what was on her phone, and then she started printing. And those are the things that found their way into the complaint. But she didn't hide evidence. That's our submission. It was what she thought was relevant. Now, whether she should have attached more, maybe this panel will find that, and in future complainants will know you must put absolutely every bit of evidence attached to your complaint. The point is that she kept that phone. She kept the phone with all the WhatsApps, everything. And she provided that when asked. She could have deleted
some of
things.
them were deleted.
No, what you have before you includes, there were things that went missing when she provided to the SAPS. She says that. But what you have before you is everything on her phone, which includes things that are not complimentary of her, which includes things that if she was hiding things, she would have deleted. We know that because she was cross-examined extensively on this vacillation and whether it was in fact unwanted attention that she was getting from the JP. Because she left in there the full conversation between them over months. So this kind of narrative that she somehow hidden evidence, we would submit is wrong and it's misleading. It's not that. It's about what she chose to attach to her complaint, having no obligation to do that. In fact, she didn't have to attach anything to a complaint, but she did. And when asked to provide evidence to this commission, she provided it, all of it. So we would submit it's a bit of a red herring. But I can deal with it more in reply if necessary.
When the JCC considered the matter, you can attend to that.
I'm so sorry. Okay, go ahead.
When the JCC considered the matter, did they have all the WhatsApp messages that we have now?
No, they did not. The JCC was required to see whether there was a prima facie case. They had the complaint and what she attached to the complaint, and they had submissions. They didn't have oral evidence, I think. I wasn't involved at that point. There wasn't oral evidence. Yeah. But they had, Ms Mengo at that point was legally represented, and there was submission, and as was Judge Mbenenge, and there were legal submissions made on behalf of both.
Do we know what conclusion would they have arrived at had they had all the WhatsApp messages?
We do not. But I stress there was no obligation on her to provide all the evidence attached to her complaint, and I'll find that provision in the Act for you. When a person complains, they are not a lawyer. Mostly, they may be advised. She was not advised. So one must be cautious about what we require of complainants. If what we require of complainants is to make a full case, including all your evidence, then we must say so. But the way in which the Act and the rules are structured suggests to me that that's not the case, because the JCC referred it to this tribunal to hear evidence on various issues that may or may not have been at issue for them, or an issue for them. That was the purpose of this tribunal.
Yeah, but that's not the point.
No,
the point is, you may not disclose everything, but at the same time, you can't omit that which is not favorable to your case. You can't.
No,
You
sure.
must make an honest disclosure.
Yes, all I can say is that she took screenshots of what she thought showed sexual harassment, which was her complaint, and she attached it.
Yes. Mr. Skakani. Sorry.
Thank you, Ms. Butlender. I heard you mentioning that the complainant never sent photos to the JP. Is that correct? Because of my memory serves him well, the JP said there is one photo which she sent to the JP, and the JP commented on that particular photo, which the JP sent, which the complainant sent to the JP. It was not a profile picture. That's how I understood the testimony of the JP. So the assertion that the complainant never sent a photo to the JP, is it correct?
It depends what photo you're talking about. She, for example, kept posting pictures on her status. So, for example, the picture of her food, a picture of herself dressed, and he would comment on those. There's a dispute about whether some of those were sent to her. She says they were her status photos. But if you bear with me, I just want to check one thing with my attorney before I give you a full answer.
Yeah, but the way I understood the JP to be saying, in one of the comments, it was not a status. It was something, it was a photo which was specifically sent to him by the complainant, which is different from when someone picks up a profile picture and makes a comment. And he tried to make a distinction between those two, to say, but hang on, there was an instance whereby she sent me specifically a profile, not a profile picture, but a picture. And I commented.
A picture of herself.
Yes,
Can I check with my attorney
please
and
do
come
so.
back to you, if you'd bear with me for a minute? Mr. Mashaba, I think that what you're referring to is potentially at page 1167 of the WhatsApps, where there's a photograph that that the JP responds with a, I don't know what emoji this is, fingers touching, saying stylish. And there is a dispute between the parties about whether or not that was a picture she sent him. She says she didn't. She said it was her status that he was responding to. So there is a dispute on that issue. But she says she did not send him pictures.
Lastly, on the issue of the no, you say there were 11 no's. Are you referring to the ayes? Because I think
No, in fact, I will provide a table just to clear up any concerns. There were a series of ways in which she said no. This is a submission. There were some times where she said the word no. There were other times where she quoted the Bible verse and referred to the first word. There were other times where she said no in different ways. It is impossible. It will not happen. You must control yourself. They were, when I say how she said no, it's how she, perhaps it's better to say how she rebuffed him, how she was trying in many different ways to say no. And I'll provide a table with all those references. This morning I counted 13, but I will provide a table to the panel.
excellent. Thank you.
Mr. Skakan.
Yes, Chair. Thank you, Chair. I won't be long. May I ask for a short break? Remember, there were paragraphs I wanted. My team just walked in when we were coming back. I just want for 5, maybe 10 minutes.
All right, maybe let's say 20. Yeah, maybe let's just have
Half
a
past.
tea break. We come back 1:45.
Yes, that's. Thank you, Chair. And
I
thank
must
you.
indicate to you that we indicated that we need to finish, but please don't feel pressured into finishing when you don't want to finish. We'll be willing to stay on here forever if that needs be.
I'll finish before 12. Chair, and thank you very much for the opportunity. I won't be long. I think first let me start by saying we say no more than what's in our heads of argument. And we've given it there in greater detail than we should. And I think it curtails the time we should spend today, oral argument. And may I also indicate that in view of what the chairperson asked for, there's a bundle, not a bundle, it's just heads of argument with references to those specific paragraphs that the chairperson indicated lacked referencing. So we've done it in there. There may be one, I think it's 349, that may not have it because it's simply a generalized comment on the nature of the evidence as a whole. And so that is not there. Chair, before I set out the scheme of my submissions today, let me just read one of the two cases that I think the tribunal must read together to understand what the truth is about sexual harassment and what factors must be considered. But I quote this because I don't want an understanding, a line that there's another tone in our argument that does not recognize the seriousness of sexual harassment as a scourge. And it's in the case of McGregor versus Public Health and Social Development, Sectoral Bargaining Council and others.
It's the same one that.
It's the same one that my
Applicant
learned
Butlander
friend, yes.
referred
I
to.
just want, because it starts with a very powerful clarion call to all of us. And it defines sexual harassment beyond what one finds in the two acts, the Pepuda, and it says, sexual harassment is the most heinous misconduct that plagues a workplace. Although prohibited under the labor laws of this country, it persists. Its persistence and prevalence pose a barrier to the achievement of substantive equality in the workplace and is inimical to the constitutional dream of a society founded on the values of human dignity, the achievement of equality, and the advancement of human rights and freedoms, and non-sexism. Not only is it demeaning to the victim, but it undermines their dignity, integrity, and self-worth, striking at the root of that person's being. Writing in 1989 in its first reported case of sexual harassment, the erstwhile industrial court, sounding the alarm that sexual harassment cannot be tolerated, highlighted that, and it quotes, unwanted sexual advances in the employment sphere are not a rare occurrence, and it is by no means uncommon, close quote. Unfortunately, the truth rings as loudly today as it did then. The only difference between now and then is that today we hold in our hands a constitution that equips us with the tools needed to protect the rights that are violated when sexual harassment occurs. Yet, what this means is that for as long as sexual harassment persists, so the Constitution becomes an eidolon and its promises of equality and dignity equally elusive. You may wonder why I'm quoting this, because to a naked eye, it sounds like I'm arguing against myself. I'm not. I'm raising this because this is a clarion call to everybody involved in an inquiry about sexual harassment. And it is a clarion call to the complainant or complainants, and a clarion call to the potential respondents in cases of this nature. But of course, it's a double-edged sword, this definition. The seriousness with which we are being warned means determining questions of sexual harassment must be done in a way that is careful, that is unbiased, that concentrates on the facts, so that in future you do not have a broad sweep and a system where any complaint is entertained, even if it undermines the legitimacy of genuine complaints about sexual harassment. The scheme of my submission is as follows. First, that I'll deal with, noting that the comprehensive heads have been filed, is that I'll do a broad summary of this case, of what this case is about and what it is not about. And this I do to avoid repeating certain things. In that first point, I will also deal with the precise definition of sexual harassment, wherein I will argue that there is a definition because we must avoid a generalized approach, one-size-fits-all approach, depending on how we feel. And I will give the definition because there have been a lot of moral questions raised, some of them misplaced, which have tended to dominate the questioning of the respondent and the condemnation of the respondent and these proceedings, and from the large community of moral high horse riders. The second topic I will deal with is an overview of the evidence without repeating it, the tenor of the evidence. And in this point is to demonstrate, as I start within the heads of arguments, he who alleges must prove. It's a basic principle. And I will show that contrary to the broad sweeping claims and moral outrage about flirting by a judge, There is absolutely not an iota of evidence showing that that flirting, which is not impermissible, that flirting constitutes sexual harassment. And while I'm there on the definition, my learned friend chose to move away from PEPUDA, the Equality Act, because she says we must focus on the Employment Equity Act. I will demonstrate that it's actually a case of jumping from the frying pan straight into the fire. It is actually in the Employment Equity Act that the word unwelcome as a factor, unwelcomed, is mentioned 8 times. In fact, in the 5 factors that my learned friend sought to rely on, it is there that the word unwelcome is mentioned 7 times and once in the broad definition. So basically, the two are not distinguishable in their emphasis of what it is that constitutes sexual harassment. Thirdly, I will traverse the general tone of the conversations between the claimant, the complainant, and the respondent. Of course, the point we've made here is the fact that some conversations were concealed. Obviously and ordinarily, no one expects us to be suggesting that in a complaint every point must be quoted. But what we are saying is that the pattern of what was selected reveals a deliberate attempt to conceal that which would reveal this important factor called unwelcome. And if the tribunal feels that, well, that's conjecture, so be it. But what we were raising is not that she should have quoted everything, but that the pattern of selecting itself, selecting particular things that do not really place you in a positive light, is itself a problem in proceedings of this nature. The fourth one is that in as far as there's been an attempt to suggest that the conversations are replete with rebuffs, and this is dealt with largely from page 43 to 44 of our heads. And it suggests that Ms. Mengo was an unwilling partner. It means was unwilling to engage. I will traverse, although briefly, the so-called rebuffs, which in our respectful submission are a creative reconstruction of the conversation, almost undermining the participants in the conversation. Fifth, and we do this from page 44 to 54, I will refer to my learned friend says he doesn't like the word salacious. My own client used the word sensual. I will use 3 of them: sexual, sensual, and salacious chats themselves, citing different dates. For example, 8 June 2021, 10 June 2021, 18 June 2021, 20 June 2021, 21 June 2021, 23 June 2021, 26 June 2021. We cite these clearly there, and I will not repeat them, but I'll move there when I deal with the argument. And the last 2 topics, or 3 topics, and which are dealt with in page 57 to 68 of our heads, will submit that the claim that the respondent sent crude pictures is a patent falsehood. There is no evidence that it happened. And to suggest post facto that we must assume it did because we can't tell that it did not has to be said to be rejected. That it was not shown. We suggest that no evidence showed that such a crude picture was sent. And we deal with this in reference to Annexure H, Annexure H1. And as I said, this is in page 57 to 68 of the heads where it's dealt with. Annexure H8, Annexure K8, sorry, K11 and K12, K13, N and P. And we show that the evidence of the expert, Dr. Moller, does not support the claim that such crude pictures were ever sent. We will, in that topic, submit that that should be rejected. And most crucially, the respondent eloquently denied it. We'll also show the futility of the expert evidence. And I think most of the questions from the chair about referencing were there. And in this one, we deal with it at page 77 to 92. It's paragraph 230 to 280 of the heads of argument. It's dealt with in greater detail there. And I will try to persuade this tribunal that both these experts failed the test that I had placed, at least we put to them, about at what point is expert evidence to be accepted and helpful to the process. And I cited the tried principles. Lastly, as a topic from page 106 to 114, we deal with what we call fabrication. I'm using the word dishonesties advisedly because I do not wish to attack the complainant there. I think the word is a little harsh, but I think we call them incongruities. I apologize for using the word dishonesties. It's harsher, and I think let's leave it at incongruities and fabrications. At the heart of this is the claim, which we say is false, that JP sent Ms. Mengo a picture of his private part. No evidence was shown to really prove this very, very painful public lie about what he did or did not do. We will also here indicate no evidence, no amount of conjecture can show that on the day of the 14th or the 15th, the incident about which the respondent has been so humiliated that he called the complainant and showed her his private part. Painful falsehood, no evidence showed, the footage did not. We will deal with those. And while I'm there, Chair, you asked the question about what was requested from the respondent requested the tracker of the movement of the complainant's car. The evidence leader said, no, that request was not made. Chair, there is a request for particulars that demonstrates that that happened. And in particular, you look at paragraph 1.1.3. But generally, the entire thing demonstrates that what was requested. So we will submit that it is mistaken. And in conclusion, Chair, we will show with reference to what we think are fabrications designed to conceal the fact that the conversations were consensual. And Chairperson, insofar as there were things that were said by my learned friend about which I think are attacks on us as a team or my respondent, you do not need to determine my conduct and whether I was brutal or not to determine this matter. I don't want to get there. I would like to go straight to what the issues of this case are about. On the first topic, Chair, as I said, you are not required to determine how flirting should be done. Whether the respondent does it elegantly or inelegantly is a matter about which reasonable people can differ. How it is done on what others would expect is quite a subjective question. And therefore, the suggestion that the problem is the manner is itself a wild allegation that no one can determine. The narrow complaint of sexual harassment brought by the complainant against the respondent is based purely on several WhatsApp messages between them. And in order for such communication to constitute sexual harassment, it must be related to sex or gender and must have, and this is the important part, unwanted, persistent, serious, demeaning, humiliating, and intimidating or threatening adverse consequences. The first of these is unwelcome. And none of these necessarily must be pulled out. In fact, there's one that has been added about who initiates. It's not a factor. It is not a factor to determine whether people consent in the discussion, to determine who starts it. You must look at the content of their discussion. And so it's for the reason that that factor of who initiates it is not necessarily a factor. It is the content and conduct of the parties engaged in the discussion that matters. The definition of sexual harassment as articulated, and I will use the Equality Code Act, but I will ask the tribunal to use the Employment Equity Act if it so wishes. And that definition says this. It too comes from a whole body of legitimate case law. It's unwanted conduct which is persistent or serious and demeans, humiliates, or creates a hostile or intimidating environment, or is calculated to induce submission by actual or threatened adverse consequences, and which is related to sex, gender. I invite the tribunal to look at both, even the one that I didn't rely on. It will find that it's defined this way, the key being unwelcome. This is the narrow ambit of this inquiry. We deal with this in the heads from paragraph 19 to paragraph 46 in our submissions. This is the classic case. Yes, I agree that it's an important case, but it's an important case because the very essence of the definition, the factor of unwantedness, if there is such a word, is absent. It's absent. It's concocted, reinterpreted, but that reinterpretation itself undermines the participants in the conversation. We can sit here for the whole day, the whole 2 months, trying to analyze in our own condescending way what people mean or what they meant. What matters is what they said and meant to each other. It is this definition of sexual harassment that is the gateway to all the things you've been asked to find against the respondent. How can a judge do this? A senior judge must not do this. A senior judge must not court this way. But first you must find, before you reach whether anything he did was dishonorable. Of course, I wouldn't court the way he does. I find it inelegant. But this is not a competition about how best to court. I do it my own way, or I used to before I got married. And he does it his own way. Yeah, my wife is listening here. But the point is, we are told that relationships of this nature at workplace are not a problem. It's the manner in which he engages. This is a murky area about which most men and women can differ. Some are elegant, others are not, and therefore it would be difficult for this tribunal to get there. What I'm suggesting is this.
Some say you must buy flowers. Some say take her to a restaurant in Santin, but in Sikukuniland, where do you get a restaurant of that kind?
You know, Chair, we say this in our heads, and it may sound facetious. It is difficult to analyze conversations of people from different backgrounds. It's much more difficult if you come from Western notions of conversation, because you are analyzing something about which you enter being superior, that you think it represents barbarism. It represents, that's why the manner, why didn't you buy her flowers? Why didn't you take her out? Inherent in that analysis is absolute prejudice and condescension about how different people approach this. And I'm not here to argue that the JP courts elegantly. I've already stated that. I don't know, but different people can approach it differently. And so to conflate what you think is an elegant way of asking one out with harassment, which is persistent and unwanted, does not find favor in the evidence that was presented before you. And so we, in the first place, ask that you consider the definition of sexual harassment, which is objective, and you look at the evidence. And that is why we preamble, or we start by saying the necessity of proof always lies with the person who lays the charge. And to suggest that all the complainant must do, or a person who must complain must do, is to simply lay a complaint. After that, we will concoct all sorts of sympathies about how they were feeling and what gender they are and what position they are. Is a dangerous approach to it. On its own, as much as it's attractive, it's an attractive, feminist approach to looking at those things. It's a dangerous approach to dealing with issues that plague society seriously. And so one must develop a precedent, not just of being general about this, but to be rigorous. It's not brutal. It's to be rigorous so that we determine the truth. And we say some of it were clearly fabrications. I've already stated some of them. So this definition is the gateway to all the accusations that have been put here was the JP acted dishonorably. The Constitution protects everybody, and we must not quote it selectively. And one of the most important things about it, its founding principles, is that what we ask for those who are our clients, we must ask for everybody. And justice is at the center, which means fairness to both the complainant and the respondent. And so selective quoting of the Constitution is itself unconstitutional. And on several occasions, so much was said to describe this case, even this morning, as unprecedented. It's an unprecedented case. It is said to be the first complaint of sexual harassment against a sitting judge in the history of our country. So what? So that we must depart from trite principles of establishing facts? It cannot be. This idea that the identity of a litigant is a judicial way, is a justification for departure from trite legal principles, is a dangerous route to take. The idea that law is an elastic that we must pull to where we want is itself a plague in society. We must be fair, we must be strict about defining things, and we must not allow false or malicious claims because that would be dangerous to future complainants. As we show in these heads, and I want to, the description of the litigant being a judge is unhelpful in determining whether the factors that constitute sexual harassment are present. They are not. Zero. And we start the overview to show this, which was my second topic, with a legal doctrine, res ipsa loquitur. And I use this, although it's a Latin term, but it's a legal doctrine. It's a Latin phrase for this. The thing speaks for itself. Now, this principle is more important when we are analyzing conversations between people who say and mean what they say and say what they mean. We keep vacillating from whether a woman can say no and no means no, to a point where we are not sure if yes means yes. And it's because we lack intellectual honesty to deal with this so that we can cut out possibilities of sexual harassment that is clear, where people are exercising power to prejudice others, men or women, but largely women. We must never, in our determination of any matter, sexual harassment, murder, or anything, reach a point where we are not rigorous because we fear that we will be called misogynist when we are thorough, we will be called brutal. It is actually the brutality, the rigor that we must apply that will determine what it is. And the first thing is to look at what happened.
I must say this. When you talk about the no and the yes, I think the record will show. I asked Dr. Vettel, a no from a woman means a no. And she quickly said yes. And then I said, conversely, a yes from a woman means yes. She hesitated and gave, and the record will show, and gave a qualified answer to that.
Yes.
Surely a no is a no, a yes is a yes. And we must respect both, isn't it? We must, where a woman has said no, we must respect her intellect and capacity to understand that and respect her decision to say no. Where, equally, where she says yes, we must respect the yes and not rationalize it.
Chair, I was going to use that example, but I mean, it's a question that was asked, and I must quickly add to this question because I know what the groups that condemn us for brutality will say. You see, it's not untrue that in where power relations are unequal, people use that power to force others to do things they wouldn't do. That's why the definition talks about an adverse and hostile environment. But it's not there for the taking. Your objective facts must show that that power was abused. The fact that that power exists on its own does not demonstrate its abuse. And what we've been told here several times is that the power relations are unequal. But of course, they are unequal. My wife is not a senior counsel, I am. The power relations may be unequal. What you must determine is whether there are objective factors before you that demonstrate that that equal power relations, if they are unequal, was abused to create a hostile environment. None of that exists throughout this conversation. What is there is a reconstruction, reinterpretation of what she may have meant. And I say this with all due respect. This tribunal must deal with this with all the truth and the facts that are there. If the chairperson asks me, for instance, I make the submission that I think in the face of a very hostile situation, not environment, and many people expected the respondent, actually, and most husbands would have, to duck and dive on these issues because they are embarrassing. None of us in this room would like our WhatsApps to be read, even to our wives or husbands. We wouldn't. So it's an embarrassing environment already. But, except maybe for one incident, I think the JP entered the terrain. Yes, it may be called arrogant, bullish, whatever. Well, this is the environment. But the fact of the matter, he cannot be accused of being evasive and lying. Not once did he deny that he wanted a romantic relationship. Most people would have denied. Most in this room. He would have ducked and dived. I'm not even certain that he dealt nicely with the question of the banana peel, but that's just me. I just think we must be able to be honest about shortcomings in a case. But the general tenor of this, between these conversations, if truth be told, is conversations between two people. Things may have gone sour, but we have no evidence why they went sour. And at no point can one, on the objective facts, without interpreting biblical meanings, that there was a rebuff, that someone was told, don't. And I mention this because a lot, we are presented as some kind of, there's an undertone from us of misogyny, whatever it is. It's not. This case is about finding out what exactly was the conversation about between the two. We may find their conversation disgusting, but it was their conversation. None of them was forced, and it's immaterial who would start the conversation about sex position. It's about what was the tenor of their conversation. Is the unwillingness there? And we will suggest that it was not. We also state that when the complainant filed the complaint, the pattern of what he did not reveal is curious. And the suggestion that we mean she must have put everything is itself incorrect. That's not what we're suggesting. But if you look at the pattern, it is where she herself is being flirtatious or agreeable to the flirtations that is not put up. The chairperson asked the question, what would have the JCC done had those been put? We don't know, but they would have been better equipped to determine whether there is a case to answer or not. And it's important for lawyers, for complainants, and everybody involved in litigation. I think you don't have to be a lawyer to know that truthfulness is correct, is a virtue. You don't need a lawyer to tell you that when you are reporting something, try and disclose something close to the full conspectus of what happened. So the idea that because there were no lawyers, somehow diminishes the ability to tell the truth is itself a bizarre suggestion. And so we say that the text messages themselves do not reveal unwillingness. Annexure K8. I deal with this because it's one of those areas about which I think my client has gone through serious embarrassment, purporting to be a picture of the alleged private part. He's still insulted on this, called by this, something no evidence was shown. And we don't make this point to trivialize a complaint or to threaten future complainants. Future complainants who have a legitimate case and know that something like this happened to them will state it. We state that no picture of that nature was sent. The tribunal will remember that I asked, and I reference this later. First, no picture of this nature was sent. But let's ask for a moment if it was. Had it been? And I asked do you know his private part? And the answer was no, correctly so. Because there would be a difference between sending a sordid, crude picture of a penis, a private part, and sending his. And where I fault the complainant, and it's no attack on her, and that's why I removed the word dishonesty, and all I'm saying is that if both, and I said it at the beginning of this hearing, that both the complainant and the respondent will never be the same after this. Because a private conversation between them made it to the public domain. Both of them. And it is subject to being judged. But it's also replete, well, not replete, it has occasions that did not happen. And how do we know they did not happen? First, we deny them. Two, the accuser cannot show them. Nowhere in these proceedings. So the respondent, as I said, never requested nude pictures, for instance, of the complainant. Not once. We are told that he asked her to he asked her to show umtla, which is the upper body, and I think that's there for itself. And what is important is whether that conversation itself was a conversation that meets the requirement, the factors of sexual harassment. We say it doesn't. No matter how disgusted we are about the conversations, those of us who are perfect, no matter how unhappy we are about the inelegant way in which they were presented, no matter how many high horses we ride from our moral place, the fact of the matter is that that we are not happy with how the two conversed is not an issue for this tribunal and was not an issue for the JP to meet. So my suggestion is that the entire conversation, the general tone of the conversation, the content of the conversation reveal two willing adults who are engaging in something that most of us may find maybe we don't like, but consensually they engage in it about sex positions, about all sorts of things most of us pretend we wouldn't do. That is not the case to determine. And of course, the other point, we've been accused of abusing culture. There's no abuse of culture. It's the point I made earlier. It is difficult to analyze a community of people from outside. First thing, when you are not in that community. But it's worse if you assume superiority of your own culture and way of doing things. It's what we say in our heads. One of our criticism of the expert and how this case is run is to pretend there is a universal truth about which everyone can agree about courting and fletching.
Mr. Sikakani, I only want to ask, this was never put to Ms. Mengo. She was never granted the opportunity to deal with this Xhosa culture. And I accept that it's different from any other culture. I accept that, but it was never put to her, and she never got the opportunity to tell us what she knows about it.
I think you're right, Judge. And this is the area where I'm analyzing the experts. That the expert, you will recall that when the expert was introduced, the evidence leader told us that she tried to find a Xhosa culture person. And so the significance of that submission is that that was correctly so with the evidence leader, because she has kept very professional about what she's saying. Correctly, she understood the danger of entering a different culture from a position of knowing the universal truth and being superior about what must be done. And so I accept that. And you will recall that when I tried to engage Ms. Mengo, which she was doing perfectly, I was stopped from getting into this area of power relations with him. I was stopped because I must do that with experts. And so I'm critiquing the expert on the question of culture. And it's not a fact that must be put to a witness. It's an analysis of experts and her legal representatives. And I accept your proposition that it was not put to her. And I'm saying that there was no need to put to her because it's not a fact. I was not putting a fact. It's an analysis, a cultural analysis. We were bombarded with a so-called aspect on power relations. And so one has to engage with what I think are inchoate conclusions on this question on culture. And I know that culture and all sorts of and religion are used to defend some of the indefensible things, but this is not the case here. This is not the case here. We were not, and that assumption that there's a culture that inherently in it there's some abuse that gets used is untrue, is prejudicial. And so we suggest, we submit that there was lack of rigor. The chair will, the panel will remember, I had to remind Ms. Vetten of the paper she quoted. She had not, she quoted a paper that I knew more than she did. And I was demonstrating to her that this is a serious case about which you do not become flippant about what you quote. And we are told later as well that at some point of the conversations, the complainant amassed courage to confront the respondent. Now, how do you assess that this is implausible? Is that you've got to assess the point of when this courage visited her and what happens thereafter. But if you look at what happened, is that at the time of this attack of courage, it comes and then it goes. And she continues with discussions with the respondent that are still sexual, flirtatious, and in our view, consensual. And so we submit that the complainant could not explain how her newly found courage quickly dissipated, and they continued with discussions that are flirtatious. One would expect that once someone has made up their minds that this ends and stops here because I don't like it.
You are referring to
the East London.
The period after the rebuff of intimacy.
Absolutely. Is that, quite frankly, it is condescending to suggest that at all times when we deal with these cases, there are moments when we must regard the woman as some kind of child that is unable to stand her ground, and sometimes we must believe her. I think the objective facts will show when a woman or a man, usually women, are in that situation, we would not be guessing as we are doing here. It becomes very clear very early that we say somebody persisted, and therefore, because they persisted, even if the persistence was not unwanted, constitutes sexual harassment, is an abuse of the legal principle. Because persistence or persisting itself cannot be isolated from the important fact that this was unwanted. Or this was consensual, I'm sorry. So her version that at some point she rebuffed is not borne out by the facts of this case at all. And the last issue in my summary of this is it's difficult to deal with the so-called incident of the 14th or 15th of November because we prevaricate. We don't know whether it's the 14th or it's the 15th, and we are told it doesn't matter. But it does. It does if one reads the entirety of what was presented to demonstrate the whereabouts of the complainant and the respondent. To say we must guess and suggest what is probable is a principle we must apply if things are unclear. The accuser has not placed before this court evidence that what happened, what she claims happened, happened. The evidence of the footage does not show, even if you wanted to do on a balance of probabilities, that it happened. It was submitted here that because we can't really know, we must assume that there is a space there where an opportunity of it happening is there.
When the secretary must have gone to the toilet.
Yes. I think it would be a bad precedent, frankly, Chair, to decide in a matter of this nature that we must decide on somebody's guilt and impeachment from their career on a surmise. Well, because there is this time you could have done this horrible thing. It's unfair to everybody to suggest this is gross misconduct claim for which the complainant and her legal representatives want his career to end. And I think if his career must end, it must end because objective facts and evidence are there so that we don't regret later. Nobody must be sexually harassed, but nobody must be falsely accused of sexual harassment by two adults who may have changed their mind post facto. Another misconception that is here is that we must ignore I was stopped by the chair during the cross-examination when I was painstakingly showing the similarities between the initial complaint, so-called initial, and the complaint before us. To reduce it to that it shows that she remembers because she's consistent is truly something that deserves no response. The point we were checking at that is that she had first said she had no access to the initial complaint. And when I took her through not just grammatical errors, spacing, full stop. In fact, I was going to spend the whole day doing it until the chair stopped me because it was so identical.
Were you surprised that I stopped you?
No.
You even showed a misplaced full stop in the one document was equally misplaced in the other document.
Absolutely.
So,
Chair, and what it demonstrates to us, and we must be truthful about these things. And if you place to me something that I think my client didn't handle well, I'll tell you. I've already said there are one or two things like I thought I wouldn't do. I wouldn't say this. But I think it's important for this to realize that first lying or telling a falsehood to a tribunal in a matter of this nature is itself inimical to constitutional values because so much can happen out of this case. So much. Somebody's case may end. Career may end. And it is equally important that we are fair to the complainant. I'm not asking that she must be ignored and that future complainants must be frightened. But I'm asking that rigor must never be taken out of legal processes because we fear that certain groups will attack us. In fact, the best way to protect this is to demonstrate to both potential harassers and potential complainants that this is a serious matter about which nobody should come unless they know their story. And no respondent, including my client, no respondent must come to be evasive. And I deny the fact that she was evasive. He was embarrassed, but advised properly, and he did it himself, that he will speak the truth about what he did and what he meant. And lastly, the invocation of power dynamics is a range topic that we deal with. And I think I don't deny, No man must deny that power relations are a factor in harassment of any kind, both sexual harassment and harassment in general of in global politics, in personal relations. But to assume that at all times power relations must dominate how we assess evidence that is before us is itself a dangerous approach to determining cases. There's a big case in this country where a determination is made by describing that the litigant is such an important person. We already have a case like that. Therefore, we will depart from tried principles. And I think it's for that reason that I emphasize that we stick to what is objective, what was put before this tribunal. Because it is only through that we can reach the other point, whether the conduct was honorable, whether it's conduct unbecoming of a judge. You must first, on what is before you, determine whether the gateway to that honorable, dishonorable honor, which is sexual harassment, has been met. And so in pursuit of these allegations, so much is said about the respondent that he behaved indecently. We've put in enough to show that nothing was shown in this regard. And so we demonstrate that this complaint of sexual harassment is entirely contrived. And this statement must not be misconstrued as undermining what sexual harassment is. My learned friend already said, nobody is saying that relationships in an environment of work should not happen. And I think linked to that is that nobody can suggest that flirting in a particular environment, any environment, is impermissible. What is impermissible is an abuse of power to get what you want by force, creating a hostile environment and doing it in a way that's unwelcome. If you meet that, if you find, Chair and the members of the panel, that these conversations were unwanted by Ms Mengo, and the evidence shows that they were unwanted,
And the respondent persisted with them.
and the respondent persisted with them, of course you have to find that, because that's the clear definition of sexual harassment. There's no way of me running away from that legality because I want a client to survive. The fact of the matter is that there are things, if the objective evidence drives you without being selective. You see, the problem that this case is argued, sometimes we must look at the context, the entire conspectus, and when you're there, you are told, yeah, but there may be a no somewhere in between. Don't look at the entire conspectus. The fact of the matter is this: objectively assessed, if this tribunal finds and pulls out clear rebuffs, communication to the respondent that I do not want you to continue with these conversations. If you find conduct of that nature or statements of that nature, you must assess them carefully and rigorously. And of course, if you find that they were unwanted, it will be difficult for you not to find that sexual harassment happened, because you're right within the frame of the definition. It would be dishonest of me as a lawyer to try and wiggle out of that. All I'm saying is that the tenor of these conversations, broadly analyzed in their context and objectively analyzed on their content, do not demonstrate unwillingness. And if all the things that are quoted, some biblical, the eyes and all of this, if they are interpreted to mean these conversations of people who were melting, who were choosing sexual positions to each other, were not consensual, we're in a dangerous path. We're in a dangerous path about future determination of matters of this nature, which are very serious. And so, as I said, the complainant dedicated several paragraphs to demonstrate that she may have rebuffed, she meant this. When she said hi, she meant this. We submit that nothing in the conversation objectively looked at, you don't have to reinterpret or reconstruct them, demonstrates a rebuff. Nothing whatsoever. And where I say both the experts, in my view, and I think I put this to them, the role of an expert is to truly assist the process. We could have found a witness, a misogynist male who wants to come and defend another man. It wouldn't have worked. We could have found a professor who probably would come here and be disgusted about this complaint. That's not what an expert does. And it's for that reason that we could, as much as we tried, to find someone who would assist is difficult. One gets tempted to find someone not to assist the process, but to assist the client. And my suggestion about Docrat, and it's said, I'm not talking about them in their absence, is that we find that their evidence leaned not in favor of the process, but in favor of reconstructing a case for a litigant, for a complainant. And so
it may be argued that regarding Docrat,
yes,
to some extent, less so.
Chair, I
some
think so.
extent.
I think so. I think to be fair to where I fault Dr. Docrat, and I don't think it's one could say it's lack of intellectual dishonesty or anything, is that it's something any expert can do. I think less so for her because, and I think it's the point that was made, is that when you don't have the entire record, that's the first thing. And two, in your attempt, you give an import to an emoji, for example, because that's, as an expert, what you think, but it's not what the two parties understood it to be. So I think her evidence tended to give an interpretation contrary to what may have been the understanding of the parties conversing. So I think less so for her, but I think the yes.
Let me catch you right there.
Please.
But despite that, at the end of this was the end of her evidence.
Yes.
He said, however, I will concede that the meaning and understanding of the messages by the parties will be as understood between themselves, not me. Something like that.
She did.
I may be summarizing here inelegantly, but
Yes.
in the end, she said, who am I to say they should have understood this message this way and that way if they, between themselves, understood it in this way? So he really conceded and stood aside for a while.
In fact, Chair, to be fair, even Ms. Verton, in the end, she does point out to the weakness of not having seen everything, and she does. I think the both of them, in the end, I think as intellectuals, they both, unlike we lawyers of parties, I think they were able to realize the deficiency of not having the entire record and imposing an interpretation. I think that is where both of them, in the end, I think fairly, looking back at their evidence, were correct. And so, Chair and members of the panel, I will take you to the evidence, but I do not want to repeat it. Is that there is a narrow ambit of the inquiry you must make. And in that narrow ambit, the word who initiates is not there. It has particular factors that you must look at. And I say this because there's a loop. You are forced to jump and look at how can a judge do this? It's not nice. It's not your gateway to that analysis. In order for you to find that the respondent did not court properly, don't know what courting properly would be, or acted dishonorably, you must first find that this complaint meets the definition, the fundamental definition of what he was brought here to answer. That's a fair way of looking at it. If you were to ask me that we must have a theological discussion about what I would do as a Catholic or what a Seventh-day Adventist would do or people of a different sect, it's a debate that we can have. But it's unfair to have that debate if you jump over the definition. And if you fall short on the definition, you cannot move to whether the conduct was dishonorable. Because that analysis is a jump to subjective questions about which nobody in this room is an expert. And as I said, the Constitution recognizes that judges, like all individuals, enjoy the rights first as human beings. And it's not, when we say freedom of association, we're not trivializing this case. We are saying we are in the realm of two adults courting. And so to impose our subjective judgments is very nice because we are people, we are judgmental, we ride a moral high horse. It's a nice thing to do. It makes us look better than the rest. But that's not the test. The test is a fundamental definition of what he was brought here to answer. Humiliating him or citing things that didn't happen to evoke emotions in society about what did not happen is itself an unjust approach. And of course, we submit that, and we do this in from paragraph 32, much more, where we say there is no residual misconduct complaint here outside the definition of sexual harassment. Nothing. And it's for that reason that we actually, when one witness who ventured into character evidence came, our witness, she was stopped because she was entering a realm, and I accept this, a realm of analyzing subjective things about a person, about Ms Mengo. And I think the tribunal was correct to stop it, but that too must guide us in how we analyze this case. We cannot then venture, if we can't meet the definition of what he was brought here to meet, venture into character. So much was said about him and all of this, or about us being brutal. It doesn't help the case. All I'm saying is that there are objective factors to be determined on this. And so, unsurprisingly, as we say in our heads, the judge president responded to sexual harassment charges only, to that charge. We could have spent time debating other things, and there was no space for that. And there is no, it's unnecessary. It's not relevant because we're venturing into things that are subjective. The test, as the evidence leader said, we look at, it's objective. We have the evidence. If there was no evidence, you would be permitted to venture into other things of interpreting. But if the accuser is unable, or nobody can place the evidence of what they say happened, it's difficult to charge people with conjecture, not in such a serious matter. Not when we are suggesting something so serious about another human being. And so he was not called upon to meet all of these cases of what is the right way for a judge to court. Can a judge who's judge president court a judge who's not judge president or someone who's working? It's a different case if we were to meet that, but we're not called upon to meet that. And it's a difficult case discussion to have because it's mingled in subjectivity. And as I said, the act, I don't even want to go to the sexual harassment policy, the recent sexual harassment policy. Because law works that way. There's always an improvement of deficiencies in how we do things. And so to suggest that we must look into a system that is trying to deal with the future in analyzing what happened is a, I know that while it's being used, we are told no, but yes, it doesn't apply retrospectively. But I think even reference to it is immaterial. It's not helpful. And we deal with the cases of Mutata and Hlophe and Kindred, and we think that reliance is misplaced for this case, quite frankly. And I don't want to bore the tribunal with things. We deal with that from paragraph 47 to paragraph 56. And I wouldn't like to repeat it because I've also dealt with what are the applicable legal principles. And I said when I started chair in the tribunal, there are two cases that are interesting to read about this because it is reading both of them that will guide taking a fair approach to the complainant and a fair approach to the respondent. It's the case that the McGregor case that I talked about. But I think the Amatole District Municipality case that we've cited this, but I will give members of the panel the proper citation. It's here. Both of them are important. I started with the one that defines the scourge of sexual harassment in society. But the Labour Appeal Court in this one, not that it's unaware of this scourge, deals with a complaint that was deficient. A complaint where no evidence of what is claimed happened is shown. A certain Mr. Fredericks is accused even of something as disgusting as one of the things the respondent is accused of here. Exactly the same. The complainant says, no, he called me to his room, to his office and asked me and showed me his private part or asked me to perform oral sex. And the court finds no such evidence exists. Not that the Labour Appeal Court is unmindful of the seriousness of sexual harassment, but it engages on each case on its own merit. That is one of the most cardinal principles of determining a matter, rather than a broad sweep that assumes that nobody in life lodges a false or a mistaken, erroneous complaint. I said in the beginning that I don't want to attack Ms Mengo, and I keep using these words because it's possible in error to do something. And that case, the Amatole case, demonstrates better because the judges in that case do go to great lengths to describe even the deficiencies in the evidence of Mr. Fredericks. But assessing objectively the entire evidence, the key areas did not happen. They go as far as saying you can't call a witness reliable when they pointed out things that did not happen. And in that case, they find that the fact that there was reference to things that could not be shown happened. Because if we cannot show that something happened, what are members of any tribunal left with? Conjecture. And if we're going to bring conjecture and assumptions as an important component of legal precedents, it's a terrible precedent. And our courts will be imperiled by an approach of that nature. So from paragraph 57, Chair, to paragraph 68, you will see that we deal with just the definition of sexual harassment, and I don't want to bore you with that anymore. And then we deal again with, in 3 topics, we show that sexual harassment claims here are based on the WhatsApp messages, all of which do not demonstrate sexual harassment. Second, we traverse WhatsApp messages and we find no evidence that crude pictures were sent. And the third topic, for which no evidence has been, these are 3 legs of this, only 3 legs of this complaint: text messages, a crude picture, and lastly, the so-called incident of the 13th, 14th in the respondent chamber. All these 3 legs of this case have not been shown. None whatsoever. What we're left with is guessing what could have been. And I submit that you can never decide a case of this nature to impeach anyone when those pillars are absent. And so we deal with those topics, and I don't want to repeat them, Chair, because if you take our heads from paragraph 71, we then quote verbatim, and from paragraph 72, we also deal with concealed messages. We can differ about what the objective or intention of concealing was, but all we know is that in their entirety, those messages about which we've been concluding that she was a willing participant, all of those were not there. This, coupled with what I pointed out in the 2 complaints, that in keeping with the theory that the complainant is a timid employee, junior employee who respects authority, in the complaint she removes a paragraph that would have demonstrated her belligerent behavior towards a court manager. And that pattern of concealment demonstrates that every communication or aspect of what happened that reveals what contradicts the theory of a complaint was removed or concealed and put up later. And so we deal with that in great detail until, I think, paragraph 100. And the topic there we deal with is also what we say are contrived explanations of agreed chats.
Sorry, I might have asked this question even before we came here. You know, this case has been heard over a long period of time with long intervals.
Yes, Chair.
Referring to the set of WhatsApp messages described as having been omitted.
Yes.
I know I met them somewhere, but what I want to know for sure is that they were translated or interpreted, all of them.
Yes.
Okay.
Yes. I think eventually they were here. They're here. There's no suggestion that they're not here. But it's not insignificant that a witness does not give you at the beginning everything, that you must extract it like a tooth, either in cross-examination or when the matter goes ahead. The important principle about complaints of such a serious nature is that they must be truthful, and defenses themselves must be truthful. Because anything short of truthfulness in determining a matter of this nature is a dangerous legal principle. It doesn't matter what I think. It doesn't matter what my learned friends think. It doesn't matter who we sympathize with. Lack of truthfulness in determining a matter of this nature is not an insignificant factor in assessing the evidence, because it contaminates. Let me give an example. If the respondent had come here, instead of agreeing that this is a sexual discussion of a sexual nature, as most men I think would have done, to duck and dive, is yes, this is romantic. Yes, this is sensual. Yes, this is sexual. Because that's the truth. It would have been utterly dishonest for someone who's called a judge president to try and duck and dive. And so truthfulness is important, even if we are not perfect. It's important when you've put a matter before a tribunal to be truthful. And this is no suggestion of perfection. Both these individuals are imperfect, but they're here, and you don't have to be perfect to know the importance of truth. And from paragraph 101,
Mr. Skakani, can I ask you one question? I'm sorry.
Yes, sir.
In the event we were to find that Ms. Mengo, in some part of her testimony, she was untruthful. Let's talk about the second complaint. That she must have had a copy of the original complaint when she made the second complaint. If we are to find that she was untruthful, does it mean then we have to reject all of the testimony, or we have to be selective on each and every item we are called upon to decide?
Thank you. I don't think so. I think it's a tried principle of arguing. It would be absurd of me to suggest that when a witness has in some way fallen short, you must reject everything that they say. I wouldn't say so. I don't think so. But I think what you must do is to assess the pattern. If that kind of untruthfulness is a pattern, well, you must decide as the tribunal what is your attitude towards falsehood. What is the impact of falsehood in our legal culture? Because once you introduce the fact that it's insignificant to have a pattern of fabrication for a witness, well, you're on dangerous territory. But all witnesses, particularly women in circumstances like this, or anybody, including my client, humiliated, when you are in a setup of lawyers and judges, it's not unknown to panic. It's not unknown not to be certain. And so where instances of Ms. Mengo or my client being uncertain, I do not think that is something for which you must reject everything about. I did cite an example. My client talked about, I had thought the banana peel really is a sexual, and she said, no, it's like a chocolate. I was entirely unhappy with that reference, and she explained it later. But I'm saying it's important that we don't reinterpret everything and the truth to conceal, because then it doesn't help the tribunal. All we are doing is just defend our clients. And I'm saying to you that if you can find, for instance, that there's a pattern of lying from my client, you have to reject it as evidence. You have to find that he's unreliable, but there isn't. But there's a pattern in Ms. Mengo of concealing what would have given a different impression. It's entirely false that she didn't have the two complaints. You don't have to be a lawyer to see this. It would be embarrassing for anyone to suggest otherwise. If she were my client, I would have completely told her, I don't accept this. And then from paragraph 101, we deal with the alleged rebuffs. And the essence there is that there was no rebuff, none whatsoever. Everything that is called a rebuff is an interpretation. We need to sit and debate it to agree that it's a rebuff. A rebuff from someone who's being harassed at some point must be clear. At some point, it must be clear. And what we've been doing is to try and reconstruct what she meant when she said I and other things. And the no's that we tried to, I'm still waiting, I'll see the 13 no's. But there was no no that actually actually or high that was not subjected to interpretation. And so we have to engage in that to know that a person says no. And the fact that we had to do that means the evidence does not show us that there was a rebuff. And the evidence shows that Ms Mengo was a willing participant in these sexual conversations throughout. And I cite there that she didn't do, but it's the 8th of June incident. Where she too flirtatiously replies. And I say this at the beginning, it is of no moment who initiates. Some ladies do initiate these days, I'm told, and it is of no moment who initiates. The content of the discussion between two people is what determines whether one is being harassed or one is being inappropriate. It's the incident of the 16th of June, which indicates that there was some discussion that were general, that was sort of inspiration. Of course, this is omitted as well because it does not form part of the theory that all that was happening was harassment. It's the incident of the 18th of June where both of them engage in that discussion. We will remember the quote, especially Rento, to which she reacted with 4 laughing emojis. This is no sign of someone who's not consenting, but this is not put. On the 20th of June, yes, it's been trivialized, the fact that she wakes up in the morning to greet him. Happy Father's Day, Jola. We make no moment in it, except that we add that if you look at the entire tone, this is not someone who is fed up or unhappy with this engagement. It's not consistent with someone disgusted and unwilling. And the reference at 24 minutes past 10 about being cute from her. And following something that says, when Ndens are shy, you make me shy. On that day, including a discussion at 26 minutes past 10, where they're talking about East London. These are people who are engaging, and no outsider can interpret it differently. And so, yes, it was trivialized when it was put to the expert that when people are engaged in courting, in discussions of this nature, toing and froing is the essence of the game. It doesn't matter where you come from. Toing and froing. The word persistence is being abused in these cases sometimes. Persisting in a way that is unwelcome, of course, constitute harassment. But persistence, pleading with someone on its own, does not constitute harassment. I would not have been born if my father didn't persist. It took years. And I'm saying persisting, not in a violent way, unwelcome way, in certain cultures, in fact, in certain cultures, if you agreed quickly, immediately, prejudice against you is visited. People think you are cheap, you lose. I'm just saying it's important that you analyze the nature of the persistence. Unwanted, causing an hostile environment. But to generalize that persistence or pleading with somebody is itself a sign that one is harassing, is a simplistic way and unrigorous way of understanding fully how people engage. And on the 21st of June, another discussion happens. We deal with it at paragraph 135, and I wouldn't like to deal with that now. And we deal with those, Chair, up to page, I think, 57. And I would like the tribunal to go through those unless there are questions as to whether, and we put references in those. 1367. 137, yes, sorry. Paragraph 137, sorry. That's on the 23rd of June, right? And we see also a discussion there where they're talking about the blood warming up. All I'm saying is that all of these chats to which we've referred here constitute nothing close to sexual harassment, even loosely defined. And the evidence we've set out there shows at no point. That's why we are at pains in this room to try and reconstruct, reinterpret, play psychologist to what could she have meant, in what state was he. It's not important to do that when you have evidence or you have no evidence of what is claimed. Chair, let me deal with the respondent briefly. I submit that in the face of a very humiliating environment I don't mean in this tribunal, of anyone having to accept that a conversation of flirting is made public, the respondent was generally truthful, accepted at all times that she sought a romantic relationship, that the discussions were sexual and sensual. If you have to assess the two witnesses, I think the respondent, on the objective facts and admitting what happened, was truthful, reliable. The questions about other questions that were irrelevant about it, but you are a married man and all of this, I think those were stopped in the tracks because we have to look at what happened. And so I think he denies justifiably all the incidents. He denies that there was at any point. In fact, in some discussions, she actually checks with the complainant if she's unhappy, but there is no unhappiness throughout. Chair, we deal with that, and
I don't know how important is the argument that you are a married man in a country where you can marry 3, 4, 5 wives.
Chair, it comes from, it comes from a temptation. It's a human temptation. I'm a Catholic, and I have a temptation to think everybody is Catholic. And so I bring Catholicism as a universal truth when I analyze things. It's a human temptation to assume that your morality, your own morality, your understanding of things is universal. And as I keep saying, it's worse when it's applied from a position of someone who believes they are of a civilizing tribe. The other one is inferior and barbaric. It tends to complicate the subjectivity of things. And you're right, Chair, in an environment like that, someone has to pursue somebody first in order to decide that they want a second one or a third one or a fourth one. As we know, I think we've only gone to 4 as the experience in this country. But my grandfather had 9. I never know. But I think it's a dangerous analysis, and it's an imposition of a particular worldview.
It deals with morality, which does not find. We're not here to deal with morality.
It deals with, but Judge Pretorius, it actually doesn't even deal with morality. It deals with what I call a worldview. Because if you say it deals with morality, inherent in that suggestion is a suggestion that there's something immoral. It deals with a human temptation to refuse other worldviews of how people see the world, the ways of being and ways of seeing and ways of doing things. And that's where we are. And that's why we have this debate about some snide attacks on culture and people. It's because basically we are failing to be intellectually rigorous about different facets in society and how people see the world and how subjectively we see the world and how we're influenced by race, by class, by ethnicity, by gender, and by class and who we are. And so sometimes we impose what we think. That's why I said in the beginning, if you ask me, would I court like the JB does? No. Is that significant? No. There may be 2 million ways of approaching somebody. I wouldn't kneel down. I never did. But most people do. Okay, sorry, Chair. I got it wrong. Chair, it's those, and we deal there with all the annexures, with Annexure 8, we Annexure H1 and H2 to demonstrate that some of these evidence of the 17th of June, for instance, that there was an image of a man muffing a woman. She relies on Annexure H1, H and H1, and it also makes reference to H2. We say Annexure H, for instance, does not depict what she says it does. And so most of these accusations that are very serious do not find favor in the evidence, and we have to reconstruct it, engage in some psychological gymnastics to get into the minds of litigants, and it's condescending and wrong if the evidence is there or not there. And Annexure 8 as well, we deal with it. We deal with K12 and K11 and 12 that relates to the 27th of June. That's the most important. And this is probably one of the most humiliating accusations, that no evidence was put before this, that the JP sent a picture of his private part. You have to hate him to believe this, even when the evidence is not there, because it's the most humiliating accusation against someone, and you can't show that he did. We deal with Annexure K13 JP. Sorry, I keep saying JP. But I think you don't lose that title. Chair, may I move to the cases we rely on that I have said? First, I don't want to deal with them. We set out a series of cases that deal with the principles of expert witnesses. And I think I've dealt with Dr. Docrat and Dr. Vetten. I don't want to belabor points about what was deficient, and I do not want to sound like attacking them in any event. All I'm saying is that their evidence fell short of the tried principles for a witness to assist a process of this nature. And so we deal with the different cases there, and we've cited them. I think it's the Kindred case is different because the judge was the employer, actually, that American case, apart from the fact that it's irrelevant and one could look at it if it offered any help. But we've said here, and we know that as much as we accept that the JP is powerful, he is no employer. And that's the difference there about, and the other cases, then it's the Price Waterhouse. I would like the AM and another versus MEC for Health, and the Dupree case. In those cases that we cite, we say demonstrate that both Ms. Vetten, more Ms. Vetten than Dr. Doctor, fell short. And I must say, in fairness to them, is that in the end, I think when one engaged with them, there was some recognition. I think it's because they are more honest than us as lawyers. They were able as intellectuals, when one points out where they fell short, the fact that they did not have the entirety of the record, which would have made their evidence more useful. They did not engage in that. And so we say here that most of it, maybe not by design, their evidence, particularly Ms. Vetten, became nothing but conjecture and her own subjective views, and sometimes borrowing from her experiences in some of the very important work she has done in legitimate cases of sexual harassment. Unfortunately, she was imposing that interpretation in a matter where the set of facts is not consistent with her experience, where women are bulldozed and women have been harassed by people who are powerful in a workplace. All she was saying is true. It's just inapplicable in this case. We all know how women are subjected to sexual harassment in different environments. Unfortunately, this one size fits all analysis by a witness is itself a dangerous legal principle. And so we deal with that, and I do not want to belabor that point. I cite, without repeating, examples. They are not they are not exhaustive of my engagement or the tribunal's engagement with the experts. And I think the evidence there is clear for both Ms. Vetten and Dr. Doctrat. The last issue is, again, I've mentioned this. We deal with this from paragraph 281, page 92 of our heads. It is this incident. It's as serious as the one about sending a picture of the private part of the so-called effect on me incident. We submit, Chair, that if you look at those dates and the vacillation between, it's not insignificant, that vacillation between the 14th and the 15th. We demonstrated that this changes at a particular point. And you see, at that point, it looks like it's a spray gun approach. I'll shoot and see what I kill. For instance, it would be insignificant to draw the distinction between 14 and 15 if on one of those days, at least, there is evidence that something happened. It would be petty to say, oh, it didn't happen on 14, but it did happen on 15. There is no evidence placed before you. To ask you to assume that there was an opportunity that it could have happened is a far cry. And it's a principle that must never, ever be applied in determining whether someone must be impeached or not. And so we submit that that embarrassing complaint about that incident, as prejudicial as it is, never happened. And no evidence was put here that it did. Okay, we deal with that bit towards the end, and then we cite all of those. And we say in the end from paragraph 292, members of the tribunal, that the objective evidence, which is a point I've been making since I started, the objective evidence negates Ms. Mengo's allegation. Nothing before you sustains the three pillars on which the complaint. If you are called upon to decide that flirting is injudicial, that flirting is dishonorable, well, we plead guilty because this was flirting. But you are not called upon to make that. And the two other incidents did not happen. No crude pictures. Objectively, we know there was none. And the so-called effect on me incident did not happen. And the footage does not show it. In fact, it is the respondent who provided his movement on the day to try and demonstrate where he was. He could account for where he was, and to suggest that because his clerk may have gone to the loo a finding must be made that he did such a despicable thing is a far cry, is absolutely a far cry, because nothing shows it. And we deal with that towards the end, and we analyze Ms. Ngai's evidence, we analyze all the witnesses, and we think there is no suggestion by anybody. It's unfair to suggest that any of those witnesses were lying. Even our criticism of the experts, it would be untrue to say they're lying. I think it's some kind of what I call inchoate analysis of events and less intellectual rigor in assessing you, and probably of having a inclination subject, because in cases like this, journalists and all of us hide that we think is right. It doesn't. It's the same as what's out there in other commission. People have solid views depending on who they like and whether they are what I call inherent confirmation bias allows them to do. And we must take that out of processes of this nature. And that's why I started by saying I have to point out, if I'm asked, what was deficient in my own client's evidence. And I have assessed it. You may not like how he quotes. You may not like, some people say he was arrogant, he's bullish. No lawyer is not arrogant. In fact, most lawyers are obnoxious. And so I think it would be unfair to make those assessments in order to determine whether sexual harassment happened. And in conclusion, we ask this tribunal to assess, for the benefit of both the complainant and the respondent, fairly and objectively what is before it, what actually happened. You can ignore my interpretations, but I submit that what is before you does not sustain any of the three pillars of this very serious, very humiliating, sordid saga. And unless there are questions, Chair and members of the tribunal, we ask you to find where the evidence takes you. And in our view, nothing takes you to sexual harassment. It takes you to something that is subjective about what we think a judge should be, what we think a married man should be, what we think a church elder should be. We can differ about that, and how we think people should court. I don't like the way Matt Donzella courts, but that's his choice. And so I am saying to to the members of the tribunal, we do not trivialize sexual harassment. It's a serious scourge. And it's for that reason that I'm asking that you are rigorous in assessing what was put before you. It's much more important than our own interpretations. I submit, therefore, Chairperson and members of the panel, that this complaint does not meet the standard of a legitimate complaint. Thank you.
The tribunal may not release you, any one of the parties, before a certain time. We are not in a hurry to release you, as long as there are some issues we feel need clarification. And to that end, we may have to adjourn for some minutes, cup of coffee, and come back again. But that said, I don't know if, for now, members of the tribunal have questions to you, Mr. Sikakani.
Mr. Skakan, I'm going to ask you the same question I asked your counterpart.
Yes.
The issue of a photo. Was there any photo from the complainant which was sent to the JP?
That issue is dealt with in our head, because it was a photo, not a status picture. It's a photo that was sent.
Thank you.
by him.
By the way, what page of your heads of argument?
Chair, let me check how we can if we are going to adjourn, can I come back with
Yeah,
the precise
it's fine.
page where
Thank
we
you.
deal with that aspect? Because
you.
I think it's my learned friend, it's a dispute. It's what it is, and I think the tribunal must find on looking at it. Does our explanation suffice? And if it doesn't, well, it doesn't. But I think it does. But I'll come back with that.
Thank you.
In fact, may I use that opportunity as well? Is that as much as I said that was the end, to probably confer with my colleagues during the break, and if I have anything to add, may I be permitted to do so? But in case they scold me about the deficiencies in my
Check
argument.
paragraph 110 of your heads of argument.
1-1.
0. Yeah, paragraph 110.
It's 1-1. Yes. In fact, I marked it. It's on the incident of the 8th, where the complainant testified that she never sent the respondent pictures directly. But she did.
Okay.
We've said that out. And that it's a dispute, it's a matter, then we've presented what we say in that paragraph. And the witness, the respondent, dealt with this question. And if his explanation is in the eyes of the tribunal insufficient, well, a determination must be made, but that's the answer. But I'll deal with it if this is not enough.
Thank you.
I think that's all we can say about
Okay.
it. Thank you.
Thank you.
May I just ask, I know there were some discussions, maybe on different occasions, about the deletion of WhatsApp messages between them. That issue was discussed between the parties. Delete, don't delete. Why did you delete before I read? Delete so that your children may not see and so forth and so on. So I'm asking this question. Was there an agreement between the parties that messages or some messages be deleted?
Chair, can I broadly? There is reference to where one asks, "Are you deleting?" and the other says, "I am," right? Or "I do delete," or "I've deleted my message," or they got. I think the only moment for that is that it just shows that both were mindful that their private conversations would be embarrassing if someone saw them. I don't think it's on its own it suggests anything else, but it's part of what we've submitted. These were two adults who were aware that their discussion was salacious and that nobody wants that kind of discussion to remain on their phone, just in case somebody else sees them. So I think it just shows that there was some meeting of minds until some point when the complainant decided to publish them. But I don't think it's relevant for determining. Yes. In fact, that I've just been shown that there are messages where one asks, "Are you deleting this?" says the complainant, asking and this because he says everything has a name. But I'll try and get and the JP says message deleted. I'm not accusing anybody. I mean that, but what it just shows is that they both did not want this footprint. Nobody does, of a conversation that is so intimate, that is so private. And I don't think that could be used either against one of them. I think both of them were mindful, like any adult would, that there is an embarrassing element in an intimate conversation becoming available for all to see, even amongst people who do the same. And that's what I called, we're all riding a moral high horse because we've not been caught. But generally, people are embarrassed about their private conversations becoming, and that cannot be used against Ms. Mengo only, or against the respondent. I just think it's the general conduct when people are engaged in private, intimate conversations.
One small matter. I don't recall.
Oh, by the way, Chair, the other issue I wanted to raise, because it's raised, it's a topic we deal with, but I think it's that kind that because he apologized, he therefore admits guilt. Yeah, I think it's a misplaced interpretation of an apology. You know, an apology for someone who's a judge when what they have done may have, not because it's unlawful, but may have offended or people find it disgusting, or the recipient on second thought thinks this embarrassed them. I think it's a civil thing to do. It's not admission of guilt. Decent things apologize.
I was asking about something. In the complaint, there was some reference to 2021. I don't know whether it was meant to be 2022. And then we were told, no, this is a misprint. It should be 2021 or 22. What is the situation there?
Can I actually check that? I don't want to give you a false answer.
Go right, please, that. Yes, please. We want that clarification.
I don't remember it.
Yeah. Or are you able to clarify that now?
I'm not, but we'll check.
Okay. And is there an argument by anybody that communication between the two parties stopped at a certain point? I'm asking this question because in your heads of argument, you refer to a year's lapse. Can you explain that, please?
Yeah, I think there's a gap in the conversations until November. From February 2022 to November, there is a gap. There is no conversation. Yes.
Let me write that. A gap from
February to November 2022.
okay,
2022.
February. Do you have the date?
That's fine. But the other incident where they communicate is insignificant. It was about using the JP's office. But
Yeah.
for relevant communication,
Yeah.
we say there is a gap of these kind of conversations from February to November
That 20.
2022. February 2022 to November 2022.
22.
Yes.
Is he giving you instructions?
No, it's
All right.
she was reminding me of something, but I think we've covered. That's I think there is that gap, but there is a communication about an office using chambers, but I don't think it's significant in any way.
Advocate Bartlander? Or should I perhaps start with you, Advocate Skippers? In possible response to some of the issues raised by, which are new?
I don't have a lot because I know Advocate Butlander has a few, but I think there's only one thing. It's not correct to say there's no evidence supporting the complainant's version that the disputed messages was sent. She testified on that. So that is evidence that must be taken into account. And it's not correct to say that Mr. Moller's evidence does not prove the fact that it was not sent. It also does not prove that it was sent. It's neither
Yes,
here nor there.
No. But that was in response to Advocate Butlender's categorical statement in which, in a heads of argument, she says, the evidence of Mr. Mola supports the fact that supports the complainant.
Yes, but it was now argued that there's no evidence that the messages were sent. That is not correct because there's viva voce evidence on that by the complainant. There's no proof. I agree to the fact that there's no concrete proof. But Mr. Moller cannot say whether or not it was sent because he cannot say from the evidence that he has here who is the sender and who is the receiver.
Yes, but
because it was deleted.
Should we say that Mr. Moller's evidence supports the complaint?
I cannot say that it supports it, but it also does not disprove it. Yes, it's neither here nor there.
Well, it's a matter for consideration. Advocate Butler, anything that arose from the heads of submissions?
Yes, Chair, just a couple of things. But before I do that, I understood that Mr. Skakane wanted to perhaps keep going if he took instructions.
He's finished.
Are you finished? Happy?
Yes,
okay.
I am.
Chair, a few things. The first thing is I had referred the tribunal to the Judicial Services Commission Act and what's required of a complainant. The relevant provision is section 14 sub 3, which requires a complaint to be made on affidavit, must set out the nature of the complaint and the facts on which the complaint is based. That is the requirement of a complainant. Mr. Skakane in his address referred to this issue of what was attached to the complaint and what wasn't. And he suggested that the additional WhatsApp had to be extracted like a tooth. There's no suggestion that anything had to be extracted like a tooth or otherwise. It's not an accurate reflection of the facts. What happened is Ms. Mengo was asked for her phone as part of these proceedings by the evidence leader. She provided the phone. In fact, she preserved the evidence for this process. The judge president chose to delete all the evidence. One might ask what was there to hide? If this was purely a consensual, flirtatious relationship, why delete everything? But the simple point is there was no pulling of teeth. There was no difficulty. She was asked to provide her phone and she did. On the question of deleting, which came up just towards the end of my learned friend's address, my learned friend suggested that there was agreement between them that they would delete. There was no such agreement. The judge president asked her if she was deleting, and she said she was, and that he asked at several points. And the first time she said yes, because I don't have space on my phone. And the second time she said yes, but in fact she did not delete. She never deleted anything. It's all there. So when one looks at the WhatsApps, you see that the deleted messages come from the respondent, not from her. He would send a message and then immediately delete it. And in fact, she asked him, why are you deleting? But there was no agreement between them that they would delete this. And so the suggestion that there was some kind of a meeting of the minds on this is not correct. In fact, it's a reflection, I would suggest, of her knowing that there was something in those WhatsApps that he was doing that was wrong, that she was preserving. She was uncomfortable with this. So there's no agreement. On the issue of culture, we're now told that the cultural argument is not a factual argument, but it's an intellectual one, and that's why it didn't have to be put to Ms. Mengo, and that it amounts to our response to the cultural argument amounts to cultural superiority. But in that very context, we're also told that we didn't have to ask Ms. Mengo for her views on this. We are accused of treating her of infantilizing our client, but we are the ones saying she must be asked. What is her view of her own culture? What is her view of the culture that she's supposed to have been, a cultural practice she's supposed to have been participating in? So there's a great contradiction there. Why does only the judge president get to explain to this tribunal his views of the cultural practice that he says they were both engaged in? Why was she not given that opportunity? It's not sufficient, I would submit, to say that this is not a factual question. It is a factual question. And it should have been put to her, and it was not. The effect of allowing this defense is to say, in the absence of her commenting on it and being given an opportunity to comment on it, is to say that this tribunal must rule on a question of what is said to be her culture as much as it is his, without her even being asked. So let's be clear. Our submission is this argument was an afterthought. It was not raised in the respondent's affidavit. It was not before the JCC. It was not in these proceedings until the very last witness brought by the evidence leader. So we would submit that there's no merit to the argument. Mr. Skakane then says that it's unfair to make these decisions on probabilities, and it's a principle that must never be applied. That's precisely what the Act requires this tribunal to do in Section 26.3, is to make a decision on the balance of probabilities. It's a civil standard. There's nothing extraordinary about that. You will evaluate the evidence on the facts as they are and make a decision on the balance of probabilities. Then we kept hearing that there is no proof. The respondents kept saying there's no proof. But there is proof. There may not be proof of certain of the explicit sexual photographs. We accept that. But there is proof before you. There's evidence before you. There's an entire file of WhatsApp messages that are the source of the sexual harassment. And one can't throw the baby out with the bathwater. One has to look at those WhatsApps, and one has to engage on what Ms. Mengo says she considered to be sexual harassment. Now, on the suggestion that it is of no moment who initiates sexual conversations, it's correct that that's not a factor in the determination of sexual harassment. That's correct. But it is notable, and it is a factor to be taken into account in determining whether or not, in determining the probabilities of what the complainant says. Because if there was just one instance in which the judge president initiated a conversation with a sexual basis, that may be one thing. But where every single time a sexual conversation is had between these two parties, it is initiated by the judge president, every single time, then that's something that gets us much closer to sexual harassment. It's a factor then that this tribunal must take into account, together with all of the factors that we've discussed today. On the Kindred case, I'm not sure if my learned friend has had occasion to read the case, but the judge was not the employer. The whole point of the case is that the individuals who were sexually harassed were clerks in the court. They were employed by the court system. I'm not sure who it is in the United States, but it's the equivalent of being employed by the OCJ. So they were not employed by him because he was a judge. And the case is relevant because it concerns the relationship between a judge and his subordinate, who was an employee of the court. So in addition, the allegations against him were sexual in nature. They involved the sending of sexual text messages, and the court found that he was guilty of sexual harassment. He resigned before the next stage of the process took place. Those are the issues that I would like to address, unless there's anything else from the tribunal.
sorry. The,
Thank you, Ms. Patlender. Just one question. I already asked you that question. The 11 no's. Where are those 11 no's? Are they the highs, or when you say the 11 no's, where are those on the WhatsApp?
We'll provide you with a list of all the instances that we count.
Okay.
They are not just high, they are all the instances in which the complainant rebuffed the respondent, either by saying no, specifically using that word, or by saying hi, or by referring to a Bible verse where the first word she pointed to was no. Those are all the instances in which we say, she was trying to say to the judge president, I'm not interested in this. But we will put that into a table form and provide it. And I'm sure if the respondent wants to respond, that he would be given that opportunity. Thank you.
Sure.
But it won't be argument that we present. I would literally list the instances and the reference to the papers, unless the chair would like something different. Okay.
perhaps what we would like to raise perhaps may be a question to you, Mr. Sikhakhane, because you said something about what the respondent is facing or not facing. This advance which the respondent initiated was during working hours and at a workplace. Shouldn't that be frowned upon, irrespective of whether subsequently the complainant agrees to the advances? Shouldn't that be frowned upon if the judge president makes advances to the complainant at work during working hours? If that is frowned upon, that may be the next leg in which you may participate. Advocate Patlender may also participate. Would that in itself be, if that is a misconduct, but would that amount to a gross misconduct? And if you're ready to answer that, if the parties are ready to deal with that, please do so. But if you want us to adjourn for 5 minutes, we'll do so. But that is the thing that we want to ask you, that forget the fact that it was the judge president. We may even ask the question, would it not be frowned upon if a manager makes advances to another manager at work during working hours? Would it not be frowned upon if Ms. Mengo is a clerk, isn't it? A judge's clerk. If another clerk, a male clerk, equivalent to Ms. Mengo, would it not be frowned upon if that clerk makes advances to Ms. Mengo at work during working hours? Consider, leave out the question of power relations. Yes, I think that.
Yes, Chair, the answer is no. No, it wouldn't.
Sorry?
The answer that whether the timing when people engage would be frowned upon or is constitute sexual harassment, the answer is no, because something must. I think.
I didn't say it constitutes sexual harassment.
Okay.
I said, in fact, I said,
Frowned upon.
even if it's frowned upon, it may not amount to sexual harassment, but at worst, maybe misconduct. But I said that I didn't opine that it could amount to
Sure.
gross.
I get you.
Yes.
Yeah. Chair, I think the timing of when people communicate, I know that some argument was made about if it's after hours, that communication is inappropriate, therefore it must be within hours. I think the timing of when people engage on its own is of no significance. What is of significance is exactly whether that communication interferes with their function or is an abuse of time, resources, and power. But whether someone sends a message that says you are cute at 8 in the morning or sends it at 8 in the evening, I do not think that debate about what's frowned upon is of any significance about the timing, unless it interferes with time and it creates a particular work environment that is defined as hostile.
Yes. But I think I should mention this. I went through the messages, WhatsApps that were exchanged and the like. I can't even count them. But there's one thing that struck me about this. It's that 99.9% of those messages were exchanged after hours. Anybody can go and check. 10 o'clock, 9 o'clock, early hours of the morning, by both of them. But outside working hours, I've looked through them. And I recognize that fact.
Sure.
But the point that I was asking was, you have spoken to it, was the concern that irrespective of whether the JP or what, is it right to take the time at your disposal at work to make that kind of approach? Well, you have spoken to it in the way that you have. I don't know whether you still want to add anything before I move to.
I don't want to trivialize it. I think it is. You see, this is why I said when we start looking at how, and I think the sexual policy may be trying to do that, is that it's difficult to try and look ahead at what is deficient in our definitions of when. And I think we'll keep improving this. What is unfair is to charge people as we think ahead. And I think that charge of what is frowned upon is a subjective consideration. And in this case, and I don't want to make any point about it, yes, they were after work and all of this, but I think what would be important in future is to look at much more clarified, and I think maybe the policy now does, clarified ways of what conduct cannot happen between people who work together and what conduct would constitute sexual harassment. And I think that's why I call some of it conjuncture, is that we're trying to look ahead, and sometimes it's correct, but that's how policy making happens. But to try and speculate about what would be frowned upon in the future must be expressed in policy, because it's very subjective how people frown upon what different. That's why I called it a world view factor. and the things that some of my colleagues do, and I frown upon them. But that's just it is. It's my background. It's my worldview. Doesn't make it unlawful. Thank you, Chair. But if you look at those messages, yes, they are after work and all of this. But I don't want to suggest that our case is made by the fact they are after work. I think our case is the fact that they don't constitute sexual harassment. Flirting is not frowned upon. Everyone who condemns it does it. It's not frowned upon in society. We don't like it when it comes out in the public, but it's not frowned upon. Thank you.
Chair,
Advocate Butland.
thank you. It's correct that all of these conversations happened after work hours, on weekends, public holidays. That is the basis. It's a big part of why we say this conduct was problematic. This conduct was problematic because here was a judge president engaging with the clerk, a secretary, after hours, but also starting off that conversation by talking about work.
But
So,
what people do after work, is it any of our business?
but yes, it is. And the code for
If the
judicial...
judge president on a Saturday morning, good Saturday morning, meets one of the clerks at the mall, and then they start talking along those lines.
Yes, there's nothing wrong with that. But that's not what he was doing here. He was engaging in sexual conversation with her that was unwanted. So what matters here that it was after hours is because it took the workplace relationship into that after hours space. So here she...
No, but they were not talking about work after hours.
They did talk about work after hours. There are many
But that's not the
messages.
essence of the complaint, is the sexual discussion after hours.
It is the pattern that we say happened, that he would start by talking about work and then move into sexual conversations. So absolutely, it is critical that that happened after hours. It is part of the pattern. But on the question that the chair asked about whether we frown upon something or not, it occurred to me that, one, we're not asking the tribunal to make a conclusion of whether something is frowned upon. It's about whether or not this constitutes gross misconduct or not. But it occurred to me to point out to the panel that to the extent that that the panel considers that what it has before it does not amount to gross misconduct, but it amounts to misconduct, then it may say so. And that has happened in other decisions of the tribunal. That would then be taken into account by the commission in due course when it receives your report, and it would then take into account under section 25B, 20 sub 5 sub B of the JSC Act, to whether or not to impose any other remedial action or remedial steps that are referred to in section 17.8. So that is also open to this tribunal.
It won't be the end of the matter.
It won't be the end of the matter. Thank you.
I think we are finished with the submissions. We will reserve our report, our decision. And submissions have been made also relating to the issue of the court of public opinion. I think if it is necessary to make that point, we will make it again, that we are going to decide this case in accordance with the law and the facts of this case, and not in accordance with the court of public opinion one way or the other. We are totally unmoved by the court of public opinion. And there has been, as Mrs. Kakan indicated, this way and that way. And surprisingly, even people who were supposed to know better just wrote articles and said something about whether or not somebody is already guilty or is not guilty. But we can assure the parties that we are not going to consider this case according to slogans or not according to slogans, or we are going to decide it according to the law and the facts and the evidence placed before us, irrespective of whatever court of the judgment of the court of public opinion may be. For that reason, we will adjourn and give ourselves time to consider the matter and then issue a report. And that said, it remains for us to thank the parties for their contributions and effort and time in trying to resolve this matter, which is not uncomplicated. Advocate Butland. Thank you very much.
Thank you, Chair.